weekly list item number 20.
May I please your lordship? Well, at pursuant to lordship's order, we have filed and compliance affidavit, my lords.
Let's see that.
And as per lordship's order, two things have been done. One squad was constituted. It was sent to that particular area, Russell block. And an inquiry, extensive inquiry was done, not only in that block, and different, some of the different blocks also.
Okay.
And your lordship will see, we have categorically stated that wherever we have, and a fresh letter has also been sent to all the collectors to see that no one is deprived of this benefit due to Aadhaar unseating, my lords.
All right.
So your lordship will see in para 2, there are people who are old age who do not, yes, ma'am.
Terminally ill, differently abled, correct.
This has been a consistent effort, my lord, but somewhere, maybe there's some lacuna somewhere which we'll try to definitely fill up, my lord.
But have they all got this?
Yes, my lord, we have also annexed some of the statements made by the people who are receiving this, despite the fact that they do not have other seeding, my lords. At annexure 2 series, my lords.
Aadhaar bypass mode. What is that Aadhaar bypass mode? I don't know.
My lord, if you do not have an Aadhaar card, then when you,
It's
either
called
you
an Aadhaar bypass mode. All right.
Please, that's 2 submissions. That's under this Rasulpur block, there are about 170 villages.
All right.
The committee that went, because obviously they cannot cover the 170 villages,
Correct.
they went to 8 villages and they have interacted with 15 families.
All right.
Who they say that have got the benefit without having Aadhaar. Now, my lords, under the NFSA Act and the rules, because under the NFSA Act, if the state is unable to provide food, then there is a provision for providing food security allowance. And so, under the rules of 2015, if my lords may allow me, I'll place those rules. The nodal officer is supposed to come up with a list of eligible beneficiaries at the end of the month and then see how many beneficiaries haven't got it and why they haven't got it. Because if they haven't got it, then they are supposed to get the food security allowance, which is computed under Rule 6 of the 2015 rules. Now, my lords, my humble submission is, because there are 170 villages and it is not clear if the 2,000 odd beneficiaries that the report was saying belongs to only these 8 villages.
Correct.
It could be in the other villages. So
Correct.
if the nodal officer who's supposed to come up with this list every month can show that there has been no, probably in the last 4 or 5 months, considering this news report is from April. So they would be fairly recent. That is an assumption that I'm making of course.
May I answer to my friend's query? Well, for that, as the Lordship Director, a fresh letter has been issued to all the collectors. And consistent steps have been taken. Well, this is a case where if somebody is not getting the benefit, he has to come forward to ask for the benefit, my lord.
No,
it is very difficult.
They're not listened to. There's a whole problem. That's why the press, somebody talks to the press because
regarding
nobody's
the press,
there to listen to them.
Regarding the press, my lord, if Lordship will allow me, I'll tell they even try to find out the authenticity of the report, my lord. If my learned friend has any idea or any concrete news as to from where these people are, let him give us a list. Let him provide us a list. Because
I have also made my due diligence and I haven't got the report.
Because, my lord, there is little authenticity with the report, my lord. Because they find out there's a freelancer, there's no permanent journalist there for Orissa Post. There's a freelancer who are working, my lord. We also wanted to find out the authenticity of the paper and who are the families. It was now also I have also asked the department to write a letter to the Orissa Post and find out who is the journalist so that we can interact with them, try to find out who are the people. And if my learned friend has the list, let him provide us the list.
All right.
Millards, and this is Millards not confined to Rasulpur block. I have Millards in my additional affidavit, which was filed in the month of January, which is before my lords. A similar survey, and the survey report is also annexed. A similar survey was conducted in Kalahandi in 5 villages. And there also, Millards, Aadhaar exclusion is one of the reasons on which PDS is not being given. So it is, so Millards, the state is right that they have issued this new notification. But Millards, unless and until this nodal officer gives us these lists, and then from there,
do we have the numbers of do you have a list of nodal officers?
Yes,
district wise?
Yes,
every district you have one nodal officer.
Yes, my lord. We have district, we have centers.
And his mobile number, where is it? Where do one find it on your website?
Yes, my lord. Everything is there on the public domain, my lord.
All right. So the only way is that you actually send emails or messages on any social media platform to these nodal officers, telling them, giving the names of people in any block or any village who've not received it because of want of Aadhaar.
That's right.
And see what happens after these instructions.
That's right.
That's the only way to go about it.
If your lordship will allow me, I'll make one submission out of the record. Well, what is the problem is some people who come for it, and there's some percentage of people who are trying to take the benefit from 2 districts or 2 places.
Maybe.
So, my lord, they are not coming for it for the verification.
What happens is, in our anxiety that there should be no duplicate,
Yes, my lord.
Genuine card holders are denied.
No, my lord, I bow down to that.
Millards, in fact, Millards, state of Orissa in 2016 and 17 has cancelled 6 lakh odd ration cards because of duplicate cards or fake IDs. So it is not like the state is not doing. And then subsequent months, they haven't done it. And this comes from the reply of the Honorable Minister of State in the Parliament. Millards, I have shared a memo, Millards, if Courtmaster can pass the memo.
Have you given her a copy?
Millards, that copy is
given me?
Yes. Previous. If my lord sees page 28, my lords, this is the answer of the
January.
It doesn't have 28.
No, the 28.
Yours have 28.
Just a
29. Page 28 is not there. 29 is there.
No, Millards, page 28. After 26, Millards.
Oh,
there's page 28, Millards. Sorry,
okay.
Millards. There has been a
right.
If my lord sees question D, Millards, whether the ministry is also aware that linking Aadhaar with ration card is leading to denial of entitlements to legitimate beneficiaries while having no impact on quantity discrepancy. And the answer, Millards, is at page 29. Under the notification dated 8/2/2017, the timeline given to all states for linking Aadhaar with the ration cards has been extended up 31/3. Until then, as per extant instructions of the department, with a so-and-so letter, states have been advised that no genuine beneficiary.
Now that they have issued
Please, Millards, the question that I was referring to is the answer is at clause A, where there is an annexure which is given just to show that the state has been deleting these fake IDs. So, Millards, the and the annexure is at page 31, Millards.
Right. Odisha.
Page 31, Millards, serial number 26 is Odisha.
6,86,000.
2016 and 2017, there has been deletions. So today, Millards, to say that some people are taking advantage and all of that, Millards, the state is deleting, Millards, people who are.
That is done when somebody comes for it, my lord. When somebody is not coming for it for physical verification, my lord, that is what the problem arises. What my learned friend, his brother, is saying, I absolutely bow down to that, my lord. Government is taking steps wherever fake IDs are, it's been cancelled. But how to find out? They have to come forward for the verification, my lord, with any, with whatever ID proof they have.
Where are your revised instructions? Last page. 18th April. An affidavit has been filed
28
by the Principal Secretary to the Government Food and Supplies and Consumer Welfare Department, dated 21st April 2022, stating inter alia that on 18th April 2022, a fresh communication has been sent to all collectors, stating that, open quotation, no eligible beneficiaries under PDS shall be denied ration due to non-seeding of Aadhaar or bank account number, unquote. The said communication containing certain other instructions has been enclosed with the affidavit. Paragraph as regards the persons mentioned in the press report of Orissa Post, dated 6th April 2022, it is stated that in order to ascertain the factual position in Rasulpur block, a state squad randomly visited 8 villages in 4 gram panchayats and noted that of the 36,097 ration card holders, 1951 having 2325 numbers of members have no Aadhars or invalid Aadhars and are suffering from old age in critically ill condition or are leprosy affected differently abled persons. According to the affidavit, these persons, open quotation, are supplied ration through Aadhaar bypass mode, unquote. The team is supposed to have met 15 families in the 8 villages who are being supplied PDS in open quotation, Aadhaar bypass method, unquote. So Ishwar Mohanty, learned counsel appearing for the petitioner, points out that in Rasulpur block, there are over 100 villages.
Yes,
And the state squad has only randomly visited 8 of them. And therefore, it is likely that there are others who may not be getting supplies due to non-linkage of the ration card with the Aadhaar number. Due to the non-seeding of either the Aadhaar or bank account number in the ration card. Sashta Patnaik, learned counsel appearing for the state, submits that there are nodal officers in every district whose names and numbers are available on the website of the department. He states that if the attention of any of the nodal officers is drawn to the persons who may not be receiving rations, despite the fresh circular dated 18th April 2022, prompt action will be taken by the concerned nodal officer to ensure that no ration card holder is denied rations for want of seeding of Aadhaar or the bank account number. Why have you enclosed all this Bombay?
My lords, the Bombay judgment was the one, my lords, because my lords had mentioned before that there are some judgments where due to Aadhaar seeding, non-seeding of Aadhaar, there was exclusion, and Bombay High Court held that you cannot do that. Supreme Court has also taken up that issue.
Honorable apex courts have also, my lord, they did it. Time and again they've said.
And in fact, my lords, I have given the parent notification, which is at page 26, which is the 8th of February 2017, where this Aadhaar seeding requirement was introduced. And thereafter, my lords, they have, in that notification also, they have said that no one should be excluded. Even if one family member has Aadhaar, the entire family should get it in that ration card. So exclusion was never the intention of Aadhaar, my lords, to start with. So therefore, my lords, to use it to exclude people, my lords, would go against the letter and
We are
spirit
not
of
doing it at all, my lord. We are not doing it at all.
All right. So you have a centralized database where you can easily find out, right? If there is same person is trying to get into
Yes, my lord.
districts.
We've been trying to do that. We're trying to bring everybody onto the public domain system, my lord. That is why, my lord, we are insisting that you give us an enrollment number. If we are trying to see that everybody is.
No, but you should have it of ration card numbers, not other.
Yes, ration card also we're doing, but we are trying to streamline the identity also, my lord, regarding the other
All right.
identification, my lord.
All right. You say, as regards the weeding out of duplicate ration cards, it is seen that the Minister of State for the Ministry of Rural Development and Consumer Affairs, Food and Public Distribution, in an answer given in Parliament on 23rd March 2022, placed statistics showing state-wise, state/UT-wise, union territory-wise, the number of ration cards deleted by the states/union territories between 2014 and 2021. So, as far as Orissa is concerned, this exercise was carried out in the years 2016 and 2017, and a total number of 686,211 ration cards appear to have been cancelled on the ground that they were duplicate or wrongly issued. Consequently, there cannot be an apprehension entertained by the state regarding the same person making a claim for rations in more than one district. Nevertheless, if the if the department does have a database of the ration card holders, it should be possible for the state to check whether this is happening. Paragraph on the next date, the court will be kept apprised. Which is the next date? That
was 19th of May for the presentation.
That is 19th May. The court will be kept apprised of the further developments in the matter.
So the copy that my learned friend is relying on, can he, inadvertently we don't have it in the file. I think
All right.
Pardon, my lord. Similar to item 25, we have filed two cases. Can you be taken up along with item 25? WTC number 10423.
And these cases are those whole fuel supply to the CPPs, captive power plants by NCL, where your lordships have interfered in so far as NALCO's case is concerned, which is at item 25. There are other units because the MSME units are the downstream units.
You have, it's already numbered, the repetition numbered.
10423 and 105.
Okay.
Two matters are there. 10423 and 10424 of 2022.
All right.
Since that is last item on the board before your lordships today.
So probably at 2 o'clock we can take it up then.
Absolutely.
We can take up all these matters at 2 o'clock.
Yes.
Just tell Mr. Palit also.
I'll also inform them.
All right.
Special weekly list, old matter, item number 1. Item 1.
And appears Mr. Notos.
Special weekly list, item number 2.
And appears.
Special weekly list, item number 3.
And appears to
Special weekly list, item number 4.
I beg pardon, madam. I seek some instruction in this matter because all are senior citizens, very 71, 72. Only I pray for a fortnight.
No, sir, we're not adjourning.
This
Certainly not.
38B matter, and your lordship has passed many orders giving liberty to the petitioners to file civil suit if they so.
Correct.
And that way, my lord will pass the order.
Or counsel the petitioner seeks leave to withdraw the present petition with liberty to approach the civil court for appropriate reliefs as may be permissible in accordance with law. Disposed of is withdrawn with liberty is paid for. Interim order stands.
Special weekly list item number 5.
My lord, don't, my lord, on the instructional point of view, when I'll be, otherwise I'll be misunderstood, my lord. And with that liberty, because I don't have any instruction on this matter, and all are senior citizens. So somebody is.
You decide what you want to do, sir. If you want to argue, we are prepared to hear you.
My lord, then allow me 1 week's time, sir.
No, we are not adjourning, sir. That 100% you can take it from us. We are not adjourning. If you want to argue, kindly argue.
Only one petitioner?
All petitioners, 5-6 petitioners are there. But then
Whatever it's, sir. You argue the case, we are prepared to hear. We're sitting only to hear the arguments. Please continue. Argue the matters.
Can it be taken tomorrow, my lord?
No, sir. We are not adjourning, sir. We are making it very clear to you. We are not adjourning.
Then my lord pass the order.
All right.
My lord, item number 5, no instruction, my lord.
All right. No instructions disposed of.
Special weekly list item number 6.
Item 6, my lord, this is contempt matter. My lord, I came to know the petitioner in the meantime died. I will take substitution by day after tomorrow.
No, sir. You have to tell us what the matter is about.
My lord, the matter is like this. My lord, the petitioner was alerted.
Sir, you don't even have a paper book. You're arguing from slips of paper.
My lord, what had happened? Somewhere it is misplaced.
No. Then we're dismissing. Sir, don't treat the court like this, sir. Kindly do not treat the court like this. The counsel for the petitioner has misplaced the petition.
Tomorrow, my lord, so that
no, sir, we're not adjourning. I'm sorry. We have to be, you're before a high court, sir. Let's be serious.
No, my lord, with apology, my lord.
No.
Because I could not get the file,
yes.
neither yesterday nor today also.
No, all these matters are announced
somewhere
well in advance, sir. These are all put up in an advance list.
Your lordship, kindly see the paragraph 1 so that order is there. I have quoted the order of this honorable court. Your lordship, kindly see paragraph 1 of the contempt petition.
Yes.
My lord, the housing board allotted a plot with core house by taking money. And that was a corner plot to be allotted to me.
Sir, not even notice has gone in this for the last 5 years, sir. You just took one adjournment for instruction. It never came up for hearing. You not even got it listed after that. Why should we take it all seriously? You're not serious about the matter. Why should we take it?
Well, it has not come thereafter. I suffered
all that is fine, sir. You cannot be appearing in a high court with slips of paper. Please do not take it so casually.
Your lordship, in 2014 to 2012, I suffered illness, got a very big operation.
Sir, all that is not an excuse to come before a high court and argue from slips of paper. I'm sorry. We have all been in the bar.
My lord,
we don't accept this kind of an excuse.
No, my lord, I know that, my lord.
Yes.
Because what had happened, I could not able to get it because somewhere misplaced.
No, it's all right.
So I pray one day time tomorrow, my lord.
Certainly not, sir.
My lord?
Certainly not. So we are not adjourning this at all, sir. Definitely not.
Your lordship, kindly see paragraph 1 and paragraph 3, my lord.
Yes.
And I came to know in the meantime, short before the person died, and I am to take a substitution. They are not obeying the order. I have deposited even the money.
See, you have not taken any steps. I don't see why we should. You say this petition was filed way back in 2007. But did not come up for hearing for even 10 years thereafter.
OJS
your lordship may attach the OJS. Come up for hearing
OJS
for more than 10 years thereafter. Full stop. On 12th July 2017, when it was listed, the following order was passed. Paragraph: the petitioner did not bother to get those instructions. Did not bother to get the matter listed. Full stop. Today, the petition is listed on it in its due course, in its turn, in due course. And the petitioner is seeking to appear before the court. The counsel of the petitioner appears before the court without the paper book and with a few slips of paper. When the court
My lord, I may be excused for
inquires,
that.
no,
My lord, I may be excused
we'll have to
for that.
record, sir. We'll have to record all that is happening.
My lord,
You know why this is
because I
called a
have to-
court of record, correct? This is called a court of record
I
precisely for
beg
this
the
reason.
apology, my lord. I beg the
No,
apology.
even we are. It's unfortunate. We only have to express our that how unfortunate all of this is. See what the High Court has been reduced to.
No, my lord,
A lawyer can walk in and argue from slips of paper. That is what you've reduced the High Court to.
My lord,
Yes.
my
It's
lord,
unfortunate. It's
my lord,
really
I know
unfortunate.
that at my stature also this is not correct.
No,
my
it's
lord,
fine, sir. It's
because
fine.
I could not get the
We are
file.
compelled to record everything that happens, so we are recording it. All right.
My lord,
Yes, yes.
I could not get the file because
Whatever.
somewhere it is misplaced.
When asked,
because old
how
file.
could he appear from slips by producing slips of paper? Counsel to the petitioner says that he has misplaced the paper book. Paragraph: the court sees no reason why any indulgence should be granted to the petitioner in these state of affairs. The petition is accordingly dismissed. As and when the petitioner is able to locate, counsel of the petitioner is able to locate his paper book, he can file an appropriate application supported by a proper affidavit for directions.
Special Euclid item number 7.
My lord, highly obliged, my lord.
My lord, I'm sorry, I'm in BC, Your Lordship. Your
Yes.
Lordship, item number 7 is a paltry amount, 63,000, Your Lordship.
All right. Counsel, the tax amount involved being insignificant, the court leaves the questions of law open and disposes of the revision petition.
Special Euclid item number 8. Item number 8.
None appears dismissed for non-prosecution.
Special Euclid item number 9.
Item number 9 and 10, Your Lordship, the file is not available, Your Lordship. 9 and 10.
Petitioner states that the file is not available. The petition is dismissed with liberty to the petitioner, counsel petitioner to revive the petition as and when the file is made available, is able to be looked.
Your Lordship.
I'm appearing for the opposite party in item number 10 minutes.
All right.
Special Euclid item number 11.
None appears dismissed for non-prosecution.
Special Euclid item number 12.
At 12, Lordship, I am permitted to place on behalf of C.R. Das. His personal difficulties. So here is the case. The question is framed, and the issue is pending before the larger bench of Supreme Court. An imposition of such as in case of Arjun Foreign versus State to Orissa reported.
In this petition, no question has been framed, sir.
No, it is not in first time it has come up. So your Lordship may admit the question before is pending before the larger bench.
After 14 years, why would we admit this, sir?
Your Lordship, even defects have not been removed till date.
That's right. No defects removed, nothing.
Here is a case, Your Lordship, permit me. This issue has been carried out to the Supreme Court.
Then you carry this also to the Supreme Court, sir.
The Supreme Court has referred to the larger bench. And
so you can carry this also to the Supreme Court.
Even yesterday, I have checked, is pending.
Right.
So this question, Lord, also may, because purely question of law, you also may consider this.
You say defects have not been removed over 14 years now. The court sees no reason to grant any indulgence in this matter. The petition is dismissed.
14 also same.
Yes, same for 14 months. All right.
And
Special Euclid item number 13.
13, I mean permitted, Lord. 13 also question of law has not been formulated in this case.
Yes.
Here the question is whether the court is...
The defects not removed in this also, sir.
Yes, all three has not government, state government, Orissa undertaking and...
Yeah.
As
you
used,
say defects have not been removed for over 14 years. The court does not wish to grant any further indulgence, dismissed for non-prosecution. Same for 14 also.
Special Euclid item number 15.
May I please, Your Lordship? Lordship, may I kindly see the order dated 31st August 2009. The questions of law has been admitted. A, B, and C.
Only one question. Whether in facts and circumstances the case alleged shortage of gold ornaments and alleged persist suppression of gems.
Yes, Your Lordship. Your Lordship, for that, we are relying upon a order of this Honorable Court. Lordship, may kindly see para 3. Whether in facts and circumstances of the case, the enhancement of turnover in absence of any material to establish that goods found short have been sold as lawful and valid as per ratio held in Mahabir Rice Mill versus State of Orissa. Your Lordship may find it at page 9 of the paper book, Your Lordship.
Yes.
Those 3 judgments have been relied upon, and Your Lordship, a cross appeal was filed. In this case, the petitioner was the respondent before the tribunal, and the learned tribunal has allowed the state's appeal without considering the cross appeal filed by the state petitioner. For that, Your Lordship, we are relying upon the judgment of Honorable Supreme Court that cross objection filed has to be treated in the same parlance of an appeal, Your Lordship, and it has to be dealt with.
But there's no question framed on that.
Yes, Your Lordship.
So let's leave that alone. Only question is the shortage of gold ornaments and gems. Who's for the department?
Malad,
Tell us.
Your Lordship, it is only the shortage and the enhancement. Your Lordship, there are 2 assessments. One is 12-4 assessment, another is 12-8 assessment.
Right.
Basing on 2 fraud case reports, 12-4 assessment has been made and enhancement has been made. Subsequently, Your Lordship, another fraud case report has been found out, and pursuant to that fraud case report, Your Lordship, 12-8 assessment has been made. And pursuant to that shortage, enhancement has been made. And the enhancement has been confirmed by the tribunal by saying that it is a separate report. So, basing on the separate report,
No. What does that separate report say? Is the question, sir?
Well, the separate report said that there is a sufficient of 11,000.
No. On what basis?
That is at tribunal page 40. Tribunal's order at page 40.
Para 4, page 40.
40.
40.
We have heard both the parties peruse the assessment order, also gone through the appeal order and considered the oral argument advanced before us at the time of appeal hearing. We find the case that only one issue is involved, which is regarding enhancement of turnover under 12-8 proceeding on the basis of separate report, which separate report which was not available at the time of original assessment completed under section 12.4. Admittedly, suppression of 11,000 were detected, held as established on account of gold ornament and gems for which the learned STO, having due regard to the past fraudulent conduct of the dealer, enhanced the turnover by 17 lakhs. In appeal, learned SCST deleted the entire turnover by offering the view that dealer was originally suppressed on the basis of 2 reports, whereby turnover 2,70,000 was enhanced, and the present suppression can cover the present suppression. We do not agree with the conclusion so arrived by the learned SCST. This is a separate report where from clear cases of suppression have been unearthed. We also came to find out there are earlier 2 reports which prove that dealer is out and out fraudulent one. Moreover, the dealer carries
nothing of this is explaining on what basis you're enhancing by 17 lakhs, sir.
Your Lordship, may kindly.
There is no material to show that the suppression for 17 lakhs.
Your Lordship, only
Your Lordship, may kindly see page 33, the order of the First Appellate Authority.
First Appellate Authority has deleted the enhancement by saying that in 12.4 the enhancement has been already made. So 12.8
Your Lordship, may kindly see second paragraph. The first 2 reports were considered in the original assessment by enhancing the return turnovers by rupees 2,70,000. Then the third report is received belatedly, for which 12-8 proceedings initiated. The date of visit as per the third report falls in between the dates of visit according to the first 2 reports. While disposing of the first 2 reports in the original assessment proceeding, the LAO considered enhancement to the extent of rupees 2,70,000 upon estimation of all probable suppression for the entire period. As such, a sum of rupees 2,67,300 has been fixed for all such probable suppressions. As per the third report, according to the LAO, this suppression to the extent of rupees 11,000 could be established, which is well within the above probable suppression limit of rupees 2,67,300.
Right.
Your Lordship,
You say, well, nothing in this, Mr. Mishra. You can't have random addition.
As your Lordship pleases.
All right. While admitting this revision petition by the order dated 31st August 2009, the following question of law was framed. Paragraph. The present petition arises from an order dated 14 September 2007, passed by the Orissa Sales Tax Tribunal, dated 14 September 2007 in essay number 812 of 2002-03. The said appeal was by the state of Orissa against an order dated 26 June 2002 of the Assistant Commissioner of Sales Tax, ACST bracket, Sundargarh Range, Rourkela, whereby the original order of assessment dated 5th August 1996 passed by the sales tax officer, Rourkela 1 Circle bracket STU bracket, was modified to restrict the to delete the enhancement of the taxable turnover by 17 lakhs on the ground of alleged shortage of gold ornaments and alleged purchase suppression of gems. Full stop. It appears that the initial assessment was under section 12 bracket 4 of the Orissa Sales Tax Act 1947 bracket OST Act, during which there were two reports considered by the STO. Stop. A third report led to a reassessment under section 12 bracket 8 of the OST Act. And this was challenged before the ACST by the SSC. Paragraph. In its order, in the order dated 29th May 2002. 28th May. The ACST intelli observed as undertake from page 33, the line, second paragraph line within the first two reports were considered up to the last paragraph. When the state then took the matter further in appeal before the tribunal, it did not agree with the conclusions of the ACST on the basis that the third report which according to the tribunal was a separate report, open petition, therefore clear cases of suppression have been unearthed, unquote. Paragraph. Having heard learned counsel to parties, the court is of the view that the tribunal does not actually give the reasons why the order of the STO enhancing the taxable turnover by 17 lakhs should be restored, and the order of the ACST maintaining the enhancement of to the extent of rupees 2,70,000 was being set aside. in cases of suppression of purchase of gems or shortage of gold ornaments, the burden is on the department to prove such shortage of the suppression. This court in Mahabir Rice Mill, State of Orissa, 1983, 54 STC 218 bracket ORI bracket. Held that there has to be some tangible material to establish that goods have been found short sold, or that there has been a suppression. In the matter of purchase of gems. Full stop. The court is unable to find any such reasons discussed in the impute order of the tribunal. Paragraph. Consequently, the question framed in this court is answered by holding that there could not have been any enhancement in the taxable turnover in the absence of evidence of shortage of gold ornaments or suppression of purchase of gems. So in other words, the question is answered in favor of the SSC and against the department. The revision petition is disposed of.
Obliged. Great.
Obliged.
Your Lordship, item number 16
Yes.
may kindly be dismissed.
All right.
Because Your Lordship, defects have not been removed till date from 2000 and also inordinate delay, Your Lordship.
All right. Apart from the fact that there's an inordinate, unexplained delay in filing the revision petition, even defects have not been cured for more than 14 years. The revision petition is accordingly dismissed.
Grateful, Your Lordship.
Special legal list item 17.
None appears dismissed now.
Special legal list item number 18.
None appears dismissed. No.
I am for the opposite party.
All right.
Special legal list item 19.
May I please, Your Lordship?
Yes.
My Lord, alleging non-compliance of the order dated 26/8/2008, Your Lordship will get the order at page 7 of the contempt petition. The contempt was filed. My Lord, now the reply has been filed to the extent that in the year 2009, the chairman of the housing board wrote a letter to the RPF commissioner for disbursement of the dues of the dues of the petitioner. In fact, thereafter, I have no instruction what steps they have taken. The Lordship may
can close the matter, sir. Please not have any instruction.
To pursue the matter before the authority, RPF.
All right. Counsel, the petitioner seeks leave to withdraw the present
I am appearing for
liberty to
I am
pursue
for
the matter of the authorities.
I am for the housing board. My case is that already been complied with. So far, VRS claims are concerned, it has been complied with. So far, the other benefits, RPFC and all these things, we have already requested them.
Already?
We have already requested them since 2009.
Them meaning who? Requested them meaning who? You have said requested them. Them. Who is them?
Requested means the RPFC commissioner matters. They are to all this amount have to be released by the RPFC commissioner matters, Regional Provident Fund Commissioner.
All right. Anyway, he's withdrawing with liberty to approach the authorities, sir. All right. This post of is withdrawn with liberty spirit.
Special legal list item number 20.
May presume. No, non-compliance of the order dated
21 to 2018, my lord, in OJC number 477 to the 1993, my lord. A petitioner not challenging the release of the salary, gratuity, and the other pension benefit scheme. But 50,000 paid, my lord. Total release was 20 lakhs, 2 lakhs, my lord. But 50,000 paid. Other dues are not released, my lord.
So you took time in 2017 to file annexures with proper pagination and also indicate pages in the index. You have not filed anything, sir.
My lord.
You see, this petition was filed way back on 18 February 2009. And no notice has formally been issued in the present petition till date. So once it went before the Lok Adalat on 30th October 2010, and when it came up for hearing several years later on 23rd February 2017, counsel to the petitioner sought adjournment. Full stop. On 25th November 2017, this court directed the counsel to the petitioner, open quotation, to file the annexures with appropriate pagination and also indicate the pages in the index, unquote. Despite more than 4 years having elapsed since then, the petitioner has not complied with the said direction. The court therefore does not propose to grant any further indulgence to the petitioner. The petition is accordingly dismissed.
Special List item 21.
Let's say this is a contempt arises out of the judgment dated 21/8/2008. And if your lordship will see the judgment, the honorable court directed the CDA authority to take the interest from the petitioner with the considering her grievance, consider his application sympathetically.
What application for what?
For allotment of a land, petitioner filed before the Kottaka Development Authority. And all the amount has already been paid to the authority. But the authority says that you are liable to pay some interest. And when the counter was filed before this honorable court, claiming that 1,28,000 rupees is to be paid by the petitioner towards interest, to which this honorable court was not convinced and said that it is very illegal, and hence we direct you to consider the case sympathetically. But no decision was taken by the Kottaka Development Authority.
So you did not file the fresh address for service of notice?
My lord, the opposite parties are not receiving the notice.
No, you have to file a fresh address. What happened?
My lord, the same address, my lord, sir. Office is one.
You have not been served till now, sir.
So only my prayer, I have filed a miscase in. My lord, I have filed a miscase to direct the CDA lawyer who is present here, my lord. He will accept one set of notice from me.
Who's for the other side? Cuttack Development Authority. They have filed a counter affidavit already.
My lord, as far as my knowledge goes, this number one Gupteswara Acharya is retired. Number two Vijay Dhala, vice chairman, perhaps he is dead. And they are no more in CDA. all of them. The Lordship may issue notice that.
Already that order has been passed, but the notice is not accepted by the authority. So that I have filed a miscase with a prayer that your Lordship may direct the CDI lawyer to accept notice from me or a copy of the writ petition, contempt petition. And it is my personal case, my lord.
CDA has a standing counsel. Who's for the CDA, please?
Dayanand Mahapatra. He was
just now here.
He was present here.
The second officer was here as he was arguing before me.
See, the thing is, in these matters, counter has been filed, so
my lord, my prayer that when I am entitled, I am liable to pay interest of rupees 15,000 only. How 1,20,000 will be demanded?
Seeking a writ of mandamus on the basis of the last, because the order is of 2008 or something like that. Better he should file against the present set of officers and get the order implemented by filing a writ petition.
And the order of this honorable court is completely violated.
So in all these years, notice is not gone, I think, in the contempt petition.
My lord, I also admit it. What shall I do when they are intentionally not receiving the notice? So that I prayed before Lordship.
Where does it say that? Addressee left without notice, it says, sir. The remark in the AD card is addressee left without notice. Therefore, we asked you to give fresh notice. You've not given any fresh notice. Fresh address.
Fresh address.
You have not found out anything. In the last 6 years, you have not made any effort to do that.
Only my humble request before Lordship. I will intimate the CDL lawyer.
No, that won't help, sir. These are individuals you have to implement.
It is individually contempt.
If they've already retired and gone, then how will CDA help?
My lord, your Lordship pass order to issuing fresh notice.
No, not at this stage, sir. Not after 6 years. Way back in 2000, on 18th May 2016, the following order was passed in the present case. For nearly 6 years now, no attempt has been made by the counsel of the petitioner to furnish the fresh address of respondents 1 to 3, and therefore no show cause notice could be issued to them. Full stop. Since it is more than 13 years since the filing of the present petition, the court does not propose to grant any further indulgence to the petitioner on this score. The contempt petition is accordingly closed and disposed of as such.
This is list item 22.
My lord, what order passed, my lord?
We can't. You apply and get a copy of it. Yes.
Item 22.
Lord, so disposed of this matter?
None appears to the petition. 22. Dismissed from the prosecution.
Special list item 23.
Item 23, my lords. This relates to the blacklisting of the petitioner's vehicle. My lords, there's no instructions as of now. My lords may kindly give me liberty if any cause of action survives.
All right. Counsel, the petitioner states that there's no instructions. It is disposed of as such.
My lords may kindly record liberty.
2010 matter, sir. Where's the question of liberty? Yes.
Special list item 24.
Item 24. Here on 3 grounds I challenge the impugn order. The first ground is that the 240 days in a calendar year he has not worked. That is will not survive under the law, because Supreme Court has clarified that 224 days will not be applicable. Second is it is a weak case that the OP number 2 was the relative of petitioner. So he selected the petitioner. This will also not lie under the law. Okay. That was the allegation.
So his retrenchment was done later on. And third is that. Which is your item number, sir? 24. What is the writ petition number? 1200 739. There is no OP number 2. No, not OP number 2. Only single OP number. You said sole OP number 2 just now. 12,739 of 2010. Correct. A counter has been filed, has not been served to me. It's all right. What is the matter about? Matter is that the retrenchment of the workman. Tell us what is wrong with the impugned award. Not so wrong. It is a weak case, I admit. But 3 grounds are there. No, I must be clarified before your lordship. I am very cautious of this court. The first ground is that 240 days working days has not worked. That will not lie under the law. All right. But so far as second ground is concerned, I have no case because the opposite party, sole opposite party, is the relative of petitioner who that time on the helm of affairs and the selected petitioner. That is the allegation. All right. You have no answer. Third is that 1 month notice or in compensation to section 25 of retrenchment has not been given. Right. This is the only case. If you're a regularly employed person, you're not even regularly employed, then how will you claim all that? All right. The challenge in the present petition is to an award dated 2/12/2009, passed by the Labour Court Jaipur. In ID case number 2 of 2007. The question referred to the Labour Court for adjudication reads as under. Take from page 8. Apparently, the factual determination, the factual finding of the Labour Court is that the petitioner did not complete 240 continuous days of work in a calendar year preceding the termination of his services. To stop further, it appears that he was appointed only at the instance of the opposite party here, who was a close relative. The appointment itself was illegal. Question of compliance, section 25, capital F of the Disputes Act 1947 did not arise. Paragraph having heard learned constitutional petitioner. Court is not satisfied that any ground has been made out for interference with the impugned award of the Labour Court. The petition is accordingly dismissed.
Special legal list item 25.
In this matter, on behalf of Sisir Kumar Purohit, I am instructed to my senior. We did not receive any counter or para-wise comment, which is noting in cause list.
What's the matter about?
This is the passing of Annexure 9, my lord. This is the Annexure 9 is the certificate proceeding. We loan from in Gramya Bank, and we already repay the loan amount, but they did not release my certificate, no due certificate, and case is stay, interim stay.
You're able to follow what she's saying on some recovery certificate she's challenged. There will be a disputed question of fact. Because the counter paravis replies that there's a counter by opposite party number 1. The prior and present petition is for quashing the certificate proceeding in certificate case number 30 of 2002. Wherein it was stated that petitioner owed sum of rupees 226,377 and it was proposed to execute the certificate by arrest and imprisonment of the petitioner. Paragraph. While directing notice to issue the petition on 14 September 2000, there was stay granted to the proceedings in the certificate case, aforementioned certificate case. So that interim order has continued since. So in fact, the matter was never listed after 14 September 2010 till now, when it is listed in due course. Paragraph. Although according to the petitioner has paid the entire dues and is not owing anything to the opposite party, the counter affidavit filed by opposite party in number 1 disputes this. It is pointed out that the margin money subsidy was not released due to deficiency in the document submitted by the petitioner to the bank. Further, and more importantly, the petitioner failed to repay the loan installment. And consequently, opposite party number 1, open petition, was compelled to file a certificate case against the petitioner for recovery of loan dues as per terms of agreement. Unquote. The above reply was filed on 24th February 2011, and there has been no rejoinder filed till date. Paragraph. The assertion by the petitioner that he owes nothing to the opposite party number 1, and the contrary assertion thereto by the opposite party number 1, the affidavit mentioned here and before, gives rise to a disputed question of fact, which cannot be possibly resolved in the present petition. Consequently, the court is not inclined to grant the relief as prayed for in the present petition. Accordingly dismissed.
Special liquid list item 26.
Option item number 26. I'm appearing on behalf of Mr. Gautam Mukherjee. His file was untraceable in our office. I've just got a copy from the honorable court.
Infructuous. This is a tender of
some 36 lakhs EMD is there, which can be refunded.
That you'll have to approach them for that.
The state has filed a counter also in this.
But the cause of action doesn't survive, sir.
Cause of action, no. That lease period is already expired since long.
The lease period in question having already expired, the petition has been rendered infructuous. As regards refund of any bid amount that may have been tendered by the, is it a bid amount or what is it?
It is an EMD.
EMD.
As regards deposit of EMD by the petitioner, it will be open to the petitioner to approach the state government.
Your Lordship may say that the court is not expressing any opinion on this.
For its refund, if so permissible in law, the court clarifies it has not expressed any opinion on the matter. So petition is disposed of.
Special liquid list item 27.
Item 27, my lord, on behalf of Mr. Secretary, matter has been infructuous.
The petitioner states that the petition has been rendered infructuous, is disposed of as such.
Special liquidity item 28.
This is intra-court appeal is by the state against the order of the Honorable Single Judge. The Lordship, there is delay of more than a year.
Then we'll do it on that, sir. There's an unexplained inordinate delay of over a year in filing the present writ appeal against the order of the Single Judge. Consequently, the court is not inclined to condone the delay. MC case number 481, 2011 is accordingly dismissed. So consequently, the writ appeal is dismissed.
Special liquidity item 29. Number 29.
None appears.
Special liquidity item 30.
Item number 30 to 35. All are arising out of one improved order in different writ petition. My lord, yes, delay, my lord, we have explained at paragraph 6 of the Miss case. My lord, here the Honorable Single Judge has disposed of the writ petition on the basis of the order passed in WPC 5640 and 5640 has been set aside.
No, what's the delay, sir?
Delay, my lord, 440 days.
We'll leave the question of law open, sir. Then there's a delay of over 440 days in filing the writ appeal. The delay is not satisfactorily explained. Consequently, the application for condonation of delay is dismissed. The writ appeal is dismissed. Nevertheless, it is clarified that the questions of law urged are left open for consideration in some other appropriations. All the 5 matters. All 5 matters.
30 to 35.
Yes.
Special weekly list item number 36.
None appears.
Special weekly list item 37.
37 filed by the state. It shows from the office note saying that certified copy of the impugned order has not been filed.
Over 11 years now, the certified copy of the impugned order has not been able to be produced. Petition is according. Appeal is dismissed now.
Special weekly list item 38.
My lord, on behalf of Mr. S.B. Jana, no instruction, my lord.
No instructions disposed of as such.
Special weekly list item 39.
May I have to?
Yes.
So far as the first item is concerned, though I have a power, but I do not have the brief because brief has been transferred. That is to be done by.
Petition has become infructuous. Or Lordship can see the impugned order. Let the banning.
No, I am not on that. I am on the second, which has no nexus with the first.
Hashtag dispose of the Your Lordship. Your Lordship can see the nature of the order passed, which is impugned before Your Lordship. The banning period was only for 6 months. That is annexure 17 at page 74. And it was challenged before Your Lordship. Now, in the meantime, 10 years have been passed.
Yes, sir.
That matter I do not hold the brief. I hold the brief in 232533.
All right, 16230, none appears. Dismissed non-prosecution.
So far as this item is concerned,
32533.
Milord. This is a completely separate matter, having no nexus with the other one.
All right, what is this
three
about?
sets up. Here is a case seeking compensation for one excavator which can be used to break the rock, which can be utilized in my business, with the alluring commitment that such a machine is so good, your efficiency will be improved, your business will be improved, so you go for this. So I purchased one. Warranty period was 6 months. Within the warranty period, when the machine was commissioned, on the very date, it started giving trouble.
And within the warranty period, on several occasions, machine was from time to time to buy out the warranty period, they are going on repairing. Ultimately, I said that you replace it. When
See,
they
in this
didn't
matter, no
replace-
notice has gone in all these years, sir.
Yeah, what has happened? Matter was over.
11 years.
Evidence was taken. Everything done.
This petition, no notice has gone, sir, for 11 years.
Yeah, because the petitioner died, he was substituted by his son. There is a poor man, my lord. Crores of rupees involved.
So this is not, writ petition is not for
He
these
will be
things,
on
sir.
the street, my lord.
Yes, yes.
Yeah, here the TISCO, why it has happened so? Because I had filed first in the Honorable Delhi High Court. Delhi High Court said that because of forum convenience, you can file it because even if a little cause of action is there, so far as Orissa is concerned, since you belong to Orissa, machine was installed there, you can file there before the Honorable High Court of Orissa. Accordingly, I have filed it, getting the leave. After I filed, the petitioner died. For that, substitution was made. In the substitution petition, that has been allowed, I think, and notice to go.
Not is to go, never went.
Milord,
Notice never went,
I
sir.
will nowhere. I have come for justice. Now, if your lordship will not entertain this, Milord, I will be nowhere. I cannot go to Supreme Court, Milord.
Why?
On the first occasion, when I told that we go to Supreme Court, in the meantime, Milord, what has happened? Supreme Court has said the mistake which has been committed by the competitive tribunal, subsequently, the jurisdiction was not there because of the repeal act. The act was repealed. Subsequently, competitive tribunal came. And thereafter, after about 1 and 2 years, notification came that the pending cases you can hear and adjudicate. Thereafter, the pending cases were heard. Twice I had personally gone there. On the last occasion, when I was absent, this case was dismissed on the ground that I have got no power to entertain such a petition because this is not maintainable. In view of the fact that there is a decision of the Honorable Supreme Court that out of contract, if anything arises, you cannot come. You will go for suit. But that was set aside, that judgment by the Honorable Supreme Court. I have given that judgment, my lord, that section 36B and section 12B are not interdependent. They are independent sections. In section 12B, no further inquiry is necessary. If the court thinks that yes, there is a privacy case and I'll take up the action and accordingly here it should be noticed. Thereafter, upon notice, parties have come. They have laid evidence after filing statement. Matter before the tribunal, matter took 10 years, my lord. After 10 years, 2 years, it was reserved for judgment. Thereafter, 2 years, the competitive tribunal was vested with the jurisdiction. So delay in this manner, my lord, I beg with folded hands, my lord. I'll be on the street. I cannot go to Supreme Court.
No, that's, you have to have a legal argument, sir, for everything. You can't convert everything to a mercy petition.
My lord?
You cannot convert every petition into a mercy petition like this, please.
No, not mercy petition.
You will have to argue in law. Tell us in law what is the point.
On the leave, Miller, I have come because he died. That is why the difficult. That the family was suffering, Miller, and one son is suffering from autism.
Yeah,
he cannot speak, Miller.
Yes,
and I have no money to go to Supreme Court because this is a case where the law is in my favor. That is an independent section. It can be adjudicated and it is maintainable. So many cases were dismissed on that particular date. Around 50 cases were dismissed. Many of them went to Honorable Supreme Court. I also advised my client to go to Supreme Court. But there are some lawyer in the Honorable High Court. They said that no, we first take a chance before the Honorable High Court of Delhi. Thereafter, we can go to Supreme Court. In the Honorable High Court, Delhi High Court, they said that forum convenience, you go to you. That is why I have come to my lord. If your lordship will not give me that liberty to hear me, my lord. I have got a substantial case, my lord, crores of rupees involved. I'll be on the street. I beg your lordship to kindly give me that leave so that I'll prosecute my case. I'll take out notice, my lord.
In law.
My lord, they are money man.
You're not arguing in law.
My lord?
You're not arguing a legal point.
Yes, legal point I'm arguing, my lord.
What
delay is not on my, from my end, there is no delay. The matter ought to have been listed. Matter was not being listed.
Which is the order you're assailing?
Despite my memos, my lord.
You are assailing the Competition Appellate Tribunal's order, correct?
Yes, competitive tribunal which came to action.
Appellate Tribunal, there is a SLP for the Supreme Court. Yes, yes. You have the act, sir.
I have got that. This act also monopoly.
Isn't there an appeal provided to the Supreme Court against the
No, 55-12 is not there. My lord, see 55. That is also I have taken a stand because it's ultra vires. Why no appeal so far as 12 is concerned is not provided?
No, 1 minute, 1 minute. Where is the Competition Act?
55 says that any order passed under such and such section. 12B is not there.
Competition Act.
Is your lordship referring to Competition Act? Relevant law is MRTP Act.
So come to 53T.
My lord.
Section 53 capital T, sir, of the Competition Act.
Section
53 capital T of the Competition Act. No wonder he's running all around the place. Look into the law, the whole problem.
$36 capital D.
53T.
33D.
53T.
A person preferring appeal to the appellate tribunal.
Sir, 53, this is the last time we will tell you, sir, we are not conducting a class here. You better listen carefully. 53T.
Appeal to Supreme Court.
Yes.
The central government or any state government or the commission or any authority or any local authority or any enterprise or any person aggrieved by the decision or order of the appellate tribunal may file an appeal to the Supreme Court within 60 days. You know, I bowed out.
Now, finally, after 5 minutes.
No, this is not under this act.
So it is passed only under this act, sir.
He might have passed.
What is might have? He has in fact passed only under this act. If you are aggrieved by an order of the Competition Appellate Tribunal, you are supposed to go to the Supreme Court. Yes.
My lord, my contention would be, my lord, for your lordship kind appreciation.
Yes.
That so far as appeal arising out of an order passed by considering the provisions of Competition Act, then only appeal will lie.
Any order of the Competition Appellate Tribunal, sir.
He is not invoking the provisions of this. He is invoking because of the notification. My lord, kindly bear with me. There is a specific notification pending cases under the Monopoly Restricted Trade Act, MRTP. If not yet disposed of, you kindly dispose of those for which a specific authority is given to you. So he's passing an order on the MRTP Act. MRTP Act gives appeal right on section 55, in which section 12B is not there. So avoided me. One or two minutes. I have my book. I'm obliged in that respect. You already pointed out 55P, 51T. Kindly send me only my prayer mirror.
Sir, you have to argue law, sir. This
Law
endless
is-
thing,
this-
everything
I
is
argued-
only
I argued-
mercy.
I have argued.
Everything can't be mercy. You better
Law on
argue
the
law.
date.
Yes.
Kindly bear
There is
with
a
me.
neat legal question
No.
here. Please argue the law.
Law on the date when
Yes.
cause of action arose, what
Yes.
was the law?
Yes.
MRTP was in force.
Yes.
Under MRTP Act, matter was adjudicated.
Right.
Only judgment was to be passed.
Right.
When judgment was to be passed, the abolition was there.
Right.
After abolition, power vested in competition tribunal.
Right.
Competition tribunal vested with the power to adjudicate a pending case under MRTP Act. Accordingly, he has disposed of.
Right.
So it shall be deemed that his power has been invoked so far as the MRTP Act is concerned.
No.
Under MRTP Act, when there is no appeal provided, I'll come to this honorable court because of forum convenience.
All right.
If your lordship not give me that relief, my lord, being a poor man of Orissa, I cannot go to Supreme Court.
All right.
I beg mercy of my lords that some justice must be given to him.
All right.
Matter will be remitted back, nothing. It is not going to be adjudicated finally. Matter will be remitted back on the ground saying that there is a decision of the Supreme Court that 12B is an independent section. You finalize the matter, you pass the judgment. Everything upon, even my lord, my note of argument was also submitted. My lord, kindly go through. Note of submission was submitted before the MRTP.
Yes. Yes. It's all right, sir. It's all right.
My lord, everything was exhausted.
Yes.
I swear, my lord, I was physically attending that court. So matter will be remitted, he will hear it. So I pray notice may go. After hearing them, my lord may pass out. At least notice may go. That is your unless prayer, my lord.
Petitioners filed this present petition challenging an order dated 3rd May 2011 passed by the Competition Appellate Tribunal, rejecting the petitioner's appeal. Petitioner's application as not maintained. That the origin of the petitioner's application was the claim for compensation filed under Section 12, Capital B of the Monopolies and Restrictive Trade Practices Act 1969, bracket MRTP Act. The claim was on the basis that the applicant had suffered a loss due to supply of a defective machine, bracket excavator, bracket supplied by the opposite party. So the Competition Appellate Tribunal has in the impugn order that in the absence of a separate proceeding alleging unfair, monopolistic, and restrictive trade practice, an application of compensation to Section 12 capital B of the Act is not maintained, of the MRTP Act is not maintained. Paragraph. Assailing the above order of the CAT, the petitioner first filed a writ petition in the Delhi High Court, being writ petition civil 6999 of 2011. By order dated 23rd September 2011, leave was sought to withdraw the writ petition to approach the appropriate High Court. Thereafter, the present writ petition was filed. Paragraph. The attention of counsel to the petitioner was drawn to Section 53 capital T, the Competition Act 2002, which reads under 53T. Apart from saying that he has no means to approach the Supreme Court, counsel the petitioner could not offer any valid explanation why the petitioner is unable to invoke Section 53 capital T of the Competition Act 2002 against the order of the impugned order of the CAT, Competition Appellate Tribunal. As regards the petitioners not having the financial means, they can always seek to invoke the Legal Services Authorities Act for appropriate assistance for pursuing such remedy. Consequently, the court is not inclined to take the present petition, leaving it open to the petitioners to invoke the appropriate remedy available to them in accordance with law. The petition is disposed of.
Special equal list item 40.
It has been dismissed, you know. No, I couldn't get it. Has it been dismissed?
Sir, you apply for a copy of the order. We're not going to repeat the whole order. Sir, there is a mic and you dictated the whole order through the mic. I'm sure everybody in the courtroom has heard it. We are not going to repeat the order. Yes.
Special equal list item number 40.
My lord, Mr. Sangneja seriously ill. Hospitalized at Apollo Hospital, my lord.
This is a tender matter of 2009-10, my lord.
Oh, I see. This being a tender matter of 2009-10, nothing really survives in the present petition. It's disposed of as such. Yes.
Special equal list item 41.
My lord. The order of award of the industrial tribunal is impugned before the lawsuit. Annexure 5 at page 27.
Notice
the learned tribunal
after valid service. All right. Yes.
For an adverse inference, drawn an adverse inference against us for non-production of some of the documents which were not in our possession and has passed the award, directing reinstatement and payment of 20,000 as compensation.
What is the age of the petition respondent, sir? What is the age of the respondent?
Presently, my lord, That, my lord, that is not on material on record, my lord. But he has abandoned the service, and since then he is no more available or reporting to us, my lord.
You should know the age, sir.
Lord, so may kindly see page 31, my lord. The workman has filed a petition praying to direct the management to produce the attendance register, logbook, gate pass register, payment register, cash book, and ship duty register from 1/6/2005 to 11/6/2006. For better appreciation of the case, but the management reply to it has filed objection mentioning that the logbook, gate pass register, ship duty register, except of the current year, the management doesn't preserve the same for years together and destroyed the old unimportant documents, and the management was only preserved some old documents such as attendance register and payment register etc. For reference, including for the year 2006, the management has only produced the attendance register and payment register such as Exhibit A and B, but has not produced the attendance register and payment register prior to January 2006. So from it is clear that the management has suppressed such document, and if such document filed, the real truth may come out, which may go against the management.
Where is this Exhibit 1, sir?
Legal order.
There is an Exhibit 1 referred to in the impugned award.
Exhibit 1, my lord.
Where is that document, sir?
Exhibit 1, my lord, they say that's an appointment.
Where is that document, sir?
My lord, that was the appointment letter, they say.
Where is it, sir?
My lord, we have not filed it, my lord. I'll file it.
What's the point, sir? You can't not file the relevant document.
My lord, LCR must have been called for.
You should file documents, sir. This is your petition.
Lord, your lords may give an opportunity.
No question. This is a 2011 matter, sir. Poor man. Yes, sir.
My lord, Well, this letter you will also kindly say I have one.
So you don't deny this, sir. You have not denied this document.
No, but we said, according to us, he did not join on that.
How did you? Okay, you simply say that and you want the labor
Because
code
you
to
have
believe
given
it.
the attendance register, my lord, for the month of January.
So you didn't produce anything at all, sir.
Yes, my lord,
You had
exhibit
no
A and-
documents,
my
even
lord,
before
exhibit-
us.
Exhibit
You have not
A-
produced anything.
Exhibit A and B, my lord, that he has taken, the court has taken into consideration.
No, what have you produced? Tell us.
Exhibit A and B, lord.
What is that?
Let me kindly see. The internal page, my lord, running page 30. Get past 30. The management has produced the Xerox copy of in the middle, my lord. The page 30, internal page 4, my lord. The management has produced the Xerox copy of the muster roll and salary sheet from January 2006 to July 2006, which are marked as Exhibit A and B respectively. On such muster roll and salary sheet, the name of the workman doesn't found place for the month of January 2006. And February onward, the name of the workman found place on both the documents along with the other employees of the establishment of the management below. And according to us, my lord, he joined on 1206 and abandoned his services on 1066.
Why would he suddenly join on 1/2/2006, sir? When there's no appointment letter for that.
My lord, this master roll and attendance register says that he has signed it, my lord, he has joined
No,
on
no,
one-
it's only photocopies, so we don't know.
because the court of the honorable court has said that for the month of January, there is no attendance, my lord, of that person or no salary is being paid.
No, no, those are photocopies that you produce, sir. These are not the originals.
Well, according to us, my lord, he has not proved that his 240 days continuous service.
What will he produce to prove that, sir? He does not have the attendance register, only you have. How will he get the attendance register? He's only an employee.
And those will not get past that should have been in our custody. Instead, it is coming from his custody.
No, gate pass, at least you are issued a gate pass, so you know you can have a copy of a gate pass.
That should have
What
been in
else
the-
can he produce? He can only produce some document that he's given while he's working. You have to be realistic about these things. He does not have access to your documents. You see, the challenge in the present petition is to an award dated 23rd September 2010 passed by the Labour Court, Bhubaneswar, in industrial dispute case number 51 of 2007. The dispute referred to the Labour Court for adjudication was as under, take from para 2, page 27. The workman produced a copy of a letter dated 25th May 2005, bracket Exhibit 1, bracket, issued by the petitioner, informing the workman that he had been selected in an interview held for the post of assistant electrical in charge of the electrical supervisor. And he was asked to join positively on or before 1st June 2005. Full stop. While the management did not dispute the authenticity of the said letter, it sought to contend that the workman did not join pursuant to that letter, but joined only on 1st February 2006. Stop. There was no appointment order as such produced by the management requiring the workman to join only from 1st February 2006. Paragraph. The documents produced by the management were photocopies of a muster roll, which according for the months January 2006 to July 2006, which apparently did not have the name of the workman. From the point of view of the workman, however, he was able to produce gate passes to show that he had been attending from 1/10/2005 onwards till 14 January 2006. So this negated the case of the management. Full stop. The labor court was left with no option but to disbelieve the case put forth by the management because of the documents produced by it not supporting its case on facts. Full stop. Paragraph. The court is unable to find fault with the labor court for having come to the conclusion that the workman indeed had completed 240 days in 12 condemned months preceding the date of his termination, and that since there was a violation of Section 25 capital F of the Industrial Disputes Act 1947, he was entitled to reinstatement. Stop. In the present case, despite service, none has appeared for the workman. Stop. It is not even known whether he's past the age of superannuation. Stop. The only other relief granted is that he's been given rupees 20,000 as compensation. Stop. Since this court, while issuing notice in the present petition on 28 July 2014, stayed the proceedings in the labor court, stayed the award passed with the labor court, there was no scope for the workman to have the benefit of the award. Stop. He also does not appear to have applied for wages under Section 17 capital B of the Industrial Disputes Act 1947. Paragraph. Consequently, the court is not persuaded to interfere with the interim award. The petition is dismissed. The interim order is vacated.
Special legal list item 42.
Lords, 42 here the award of the Learned Industrial Tribunal is under challenge. Lords, your main grounds of challenge is the delay part. There is an inordinate delay which has not been substantially explained, my lords. Recently only, my lords, have passed a similar order, my lords, setting aside the order on this ground. Because I am submitting a my lords, copy of the order, my lords. If, my lords, here also, my lords, after a period of 10 years, my lords, the dispute was first referred by the workmen's union, my lords, before the labor code, and that there has been no my lords, satisfactory explanation rendered, my lords. That has also not been taken care of by the industrial tribunal, my lords. And though, my lords, the tribunal has held the issues against the workmen, but thereafter drawing adverse inference has directed for payment of compensation of 20,000 to each of the employees. There are 57 employees, my lords. And dispute relates to the year 1995, and they raised the dispute first time during the year 2005, my lords, 2004, my lords, 38, 2004. That we have stated in the written statement also at page 25 of the written statement. And my lords, page 44 of the tribunal's order, my lords, may kindly refer to. They have also specifically, it was clearly observed that
when was the termination?
My lords, Ali's termination date is 1995, my lords. They have just annexed a list of documents that is at page 20 of the conciliation officer's report, my lords. And that apart, there is no other materials or evidence produced by the workmen to show the duration of their employment, my lords. There is no document available. And much less, my lords, the
No, what is
present
your case?
management.
When were the services terminated? What is your case?
My lords, our case is that we came in the year 1998 after the Odisha electricity reforms transfer rules came into force, my lords. And the dispute relates prior to the coming of this establishment, NESCO, my lords, which has been now taken over by Tata Power, my lords.
No. When were the services of the workmen terminated?
Under the Odisha State Establishment Board, my lords, erstwhile.
Sir, when? When means what?
My lords, 1995 is the termination date. They have alleged, my lords.
No, date meaning where are the
that
dates
also
given?
that is also not, my lords, known also. Not there is no record available with us also, my lords. And most importantly, in the claim statement, they have also not mentioned anything regarding their date of engagement or date of termination or the duration of the.
No. For you to say that the claim is belated, there must be some date.
My lords, it was referred to the district labor officer in the year, my lords, 3/8/2004, my lords, at page 25 of the written statement at Annexure 3, my lords. We have also averred that.
And when was this reference made?
Reference was made after
2007. So why is it belated? If the conciliation failed in 2004.
Conciliation failed in 2007, my lords. Thereafter, it was referred. Conciliation report is at Annexure 2, my lords.
Let's see the claim petition first. What do they say?
30/12/2006, my lord.
Let's see the claim petition. When do they say they were working?
Claim petition is Annexure 1, my lord. Page 14. They have not stated anything in detail, my lords. Only produced some list of documents, that is experience certificates. That has already been, my lords, by the tribunal. It has been held that those are not relevant, my lords, and not sustainable. That is in award, my lord. That
let's see your written statement. What do you say,
my lord? That is at Annexure 3, my lords, page 24. At para 5, my lords, page 25.
All right. You're a new management, is it?
New management. Now, recently only it has been taken over by Tata Power, my lords, Northern Odisha Distribution Limited, TPNODL. So that, my lords, on my oral submission, maybe, my lords, changed, my lords.
Except opposite parties 53 and 56, service of notice has been effected upon all the other opposite parties, despite which none appears on their behalf. There is a substantial representation of the opposite parties. Paragraph. There is a substantial completion of service. There is therefore completion of service on a substantial number of opposite parties, barring just two of them. Paragraph. The challenge the present petition is to you don't have to be substituted by the new entity.
That is required, my lords. May I pray on my oral submission only, if maybe everything, all liabilities, responsibilities has been taken over, my lords, as it is, my lords.
By the
From
Tata
NESCO
Power
to TPNODL, my lords.
The oral request to the petitioner. The petitioner is substituted by the Tata Power North Orissa Distribution Limited. Well, cost title shall stand amended accordingly. Then you say the challenge the present petition is to an award dated 2nd April 2011, passed by the Industrial Tribunal Bhubaneswar in ID case number 7 of 2007. The following dispute was referred to the Tribunal for Adjudication. Take from page 34, bottom. Paragraph. One of the defenses taken by the petitioner before the labor tribunal, before the tribunal, was that the claim raised by the opposite party workmen was belated. In para 5, the written statement, it was stated as under. Before the labor court, it was stated as under by the management, by the petitioner management. Take from page 25, para 5. In the impugned award, the tribunal does not appear to have discussed the above aspects or given a decision thereon. So if indeed even the claim by the opposite party workman in the first place was belated, that is, it was filed 9 years after the alleged dates of termination. Clearly, the burden was on the workman to show the reasons for the inordinate delay in approaching the labor court. However, a perusal impugned order award reveals that said aspect was not examined at all by the tribunal. Paragraph. In similar circumstances, this court, by an order dated 9 March 2022, in the petition civil 3604 of 2007, bracket management of Wesco versus Shri Kunja Bihari Malik, bracket, set aside the impugned award in that case on the ground of the delay in filing the claim not being satisfactorily explained by the workman. Paragraph. In the present petition as well, the impugned award does not reveal any consideration of the said aspect by the tribunals. Consequently, the impugned award is hereby set aside. The petition is disposed of.
Special equalist item number 43.
43 billets permitted to withdraw with liberty to approach the authority.
All right. Counsel petitioner seeks leave to withdraw the petition with liberty to approach the authorities. The post office withdrawn liberties.
Special equalist item 44.
Annexure 1, my lords, is under challenge, my lords. Here, this is a matter under the OEA Act, where the suo motu revision under 38 capital B has been allowed, and the orders of the Tahsildar dated 2011-79, 27-12-91, and the order of the collector 26-2-99 has been set aside. So 3 orders have been set aside, and the Board of Revenue has reversed all the findings. If my lords would allow me, may I place the order of the collector? Because what was the issue? It appears that the Board of Revenue has gone on a tangent. If my lords would see the order of the collector.
No, what about service of notice?
It's notices were served, my lords, on the state. So it's between the petitioner and the state. In both the writ petitions, the same order is under challenge. And earlier, the records were directed to be called for from the Board of Revenue, the original records. I mean, item number 44.
Yes, yes. So nobody's entered appearance right from the beginning, is it? The opposite parties?
Yep. Opposite party, state.
State opposite party.
State of Orissa.
State opposite party. All right.
So they have appeared, my lords. They have not filed their counter.
But there is a stay operating in your favor.
Yes.
Status quo, I think.
My lords.
What's the main ground of challenge?
My lords, here the Board of Revenue has proceeded that as if it's a matter under Section 5 of the OEA Act. In fact, I'm backed by one recent judgment of your lordships, where your lordships have held that these tenancy matters are automatic and it's an order under Section 8. These are in the nature of administrative orders, and hence no further confirmation is required. So the basic premise on which the order is passed, that it is an order under section 5, and since it was not sent to the Board of Revenue for approval, it is bad in law. That is the first error. Second error, my lords, is they have relied on the Forest Conservation Act 1980 to hold that these lands could not have been given to the petitioner. Now, these settlements were in the year 1949 by the Nagra estate zamindar, and the Forest Act 1980 couldn't have been taken into account. That's, my lords, the second point. Third point is that they are saying that these orders are all photocopies, and hence, since photocopiers are not available at that time, hence it is forged. That was nobody's case. So if my lords would see the order of the collector, where the revision also was, the state lost in the revision, the issues were something different. If my lords would allow, I'll show the order of the collector, my lords. At running page 62,
Revision was preferred by the state for the collector, and I'll just show some of the findings of the collector. Page 60. Both GP, this is an interim order dated 4/12/1998. Both GP and advocate for defendants are present. Defendant advocate challenged revision petition on the following grounds. Under what law this might have been stated?
Issued by ex-zamindar of Nagra was misplaced by officials. So whether Samuel Oram is to be penalized for what mistake, for that mistake, Tahsildar in his order in 27/78 has established possession of Sri S. Oram from 1949-50 to 1979. So if rent assessment is challenged, whether possession could be disputed. Hukumnama issued before 1949 is valid and binding, can be challenged in court of law. He also stated to file relevant cases so and so. OP requested to go through the doubts raised by the defendant. I'm sorry, my lord. GP requested. GP requested to go through the doubts raised by the defendant, allowed him to produce the relevant material and facts. He should put up in arguments on 15/12/98. Then, my lords, the final order is at page 63. Last portion at page 63. May I place, my lords?
Not the entire one, just the operative portion.
Now, some of the portions relevant would be at page 64. The petitioner, in this case, the petitioner was the state. The petitioner in this revision at page 64, I'm placing. The petitioner in this revision challenges the order of the Tahsildar mainly on the ground that the Hukumnama case record bearing reclamation number so-and-so, concurring with the Hukumnama granted by so-and-so in favor of Samuel Oram is not available in Tahsil office for further verification. The other grounds taken in the revision petition is that assessment is not in conformity with the provision of mutation manual, and the Tahsildar has also not considered the Amin's report in connection with the provision of law. It is further stated by the petitioner that the aforesaid orders of the Tahsildar Kuanmuda are otherwise bad and so and so. So these were the grounds of revision, that the records are not available and the assessment of rent is not proper. Now, my lord may kindly see page 65. The collector records that all the records were produced before him and certified copies of the entire case record of reclamation so-and-so was produced. This is very important. So the collector had all the certified copies before him, and then ultimately the collector held that there is no infirmity in the order passed under section 8 of the OE Act. Now, my lord may kindly see the impugned order, which is at annexure 1. Paragraph 6. The main ground for which the Board of Revenue has reversed is they have proceeded that the confirmation of Board of Revenue required under section 5 of the OEA Act were not obtained by the OEA collector concerned for both hukumnamas mentioned above. Therefore, both the hukumnamas are deemed to have been cancelled by the OEA collector. So this is a fundamental error, my lords. This was a matter of tenancy under section 8. And these, if my lord would see my lord's own order, paragraph 12. Yes. And all along before the Board of Revenue, we appeared and we indicated that those notes of submissions are also all available, that these are all administrative orders. Section 5 will not come into the picture. Now, my lords, may kindly see paragraph 12. In fact, the consequence of vesting of estateship stand described in section 5 of the OE Act. The consequences as enumerated in clause A and so and so of section 5 of the OE Act shall ensue post publication of notification under so and so, insofar as continuity of tenure of tenants immediately before the date of vesting is concerned. It has been dealt with under section 8 of the OE Act, according to which any person before such vesting of an estate in the state government, if was in possession of any holding as a tenant under an ex-intermediary, shall on and from the date of vesting be deemed to be a tenant of the state, and such person shall hold the land with the same rights and subject to the same restrictions and liabilities as he was entitled subject to immediately before vesting.
So you say this is a section 8.
8. So the
Not
first,
section 5.
Not section 5. And thus the basic premise itself was wrong. And thereafter, my lords, all along they have gone on a footing that as if some malpractices happened since 79 and everything has been suppressed. These were all open orders passed in courts. It was challenged before the collector. Now the grounds which were there before the collector, they have been all given a go by. A new case has been made out, and on this ground that it is forged, all this was produced before the collector. So from where they are getting that these were all forged and hence they are liable to be struck down?
Yes, Mr.
My lord, the OA, this impugned order, my lord, has been allowed because on 4 grounds, my lord. First, the hukumnama was eventually found to be forged by the reviewing authority.
Where is it?
My lord, your lords may kindly come to paragraph 16 of the judgment.
Yes.
As described. Just my reading. It is seen from the original application dated 26th of December 1978 of one Samuel Oram, the father of the opposite party, that he claimed the suit land on the basis of reclamation Hukumnama case number 453 of 1949-50. He has produced the so-called certified copy of reclamation Hukumnama case number 453 of 49-50 from the court of Nagra Estate, Kuarmunda. Apparently, the certified copies were obtained from the office of the sub-collector Panpost on 21st of November 1975 and from the Tahsil office Panpost on 29th of January 1981. There are sufficient reasons to believe that the so-called certified copies of the documents, only photocopies of the documents and not the original, filed before the collector Sundargarh, are fraudulent documents for 2 reasons. First, the so-called certified copies supplied from the office of sub-collector Panpost on 21st of November 1975 is purported to be Xeroxing certified copies, but there was no Xerox machine available in Orissa or perhaps anywhere in India at that point of time. This is a fabricated and manufactured document of a much later point of time, which was produced at the stage of revision RP case number 3 by 1998 before the collector Sundargarh. It is pertinent to mention here that no such document was filed in the original miss case number 27 of 1978 in the court of Tahsildar Panpost. There is no reason as to why registers and documents of ex-Jamidar Nagra Estate would be available with sub-collector Panpost, since Tahsildar Panpost is the custodian of such records. Secondly, it is clearly mentioned in the revision petition filed by the revenue officer Panpost before the collector Sundargarh that there is no such case record or documents available in the office of the Tahsildar Kumarmunda. This fact is further confirmed in letter number 3759 dated 12th of November 98 of Tahsildar Panpost written to revenue officer collectorate Sundargarh and available in LCR of revision case number 3 of 98 of collector Sundargarh. From the above discussion, the conclusion is unavoidable that the reclamation Hukumnama of case number 453 of 1949 of the court of Nagra Estate Kumarmunda, the basis of claim of the opposite party of the suit property, is a fabricated and forged document. But he has, in fact, my lord, from the starting from 1978, from 1949 till my lord 1975, the Xerox copy when it was submitted, the authority gives a definite finding that at that point in time Xerox machine was not available. The question of and the original copy of that Hukumnama was never with the present petitioner. So if the petitioner is claiming the rights under the OE Act, then he should have produced the original one. And instead of he has submitted the photocopy of that.
There's a difference between a section 5 proceeding and section 8 proceeding. That is what is argued.
But
The hukumnama is relevant for a section 5 proceeding, but not for a section 8 proceeding.
Yes, my lord. So first of all, my lord, the hukumnama, if at all, my lord, so far as the genuineness of hukumnama pursuant to which the petitioner is claiming, the authority has clearly disputed the genuineness of the hukumnama. Now, second, my lord, your lordship may kindly see the second ground on which they have rejected.
You're not answering the question.
My lord.
Why was it incumbent on him to produce a hukumnama at all if he's not claiming under section 5?
No,
his case is that his claim is under section 8.
No, para 16, my lord, your lordship may kindly again, my lord, see para 16. It is seen from the original absence of 1978. The father of the opposite party that he claimed the suit land on the basis of reclamation hukumnama. So his claim was on the basis of that hukumnama. Lord, the very basis on which the petitioner claims his title, only on the basis of hukumnama. Right. Now, the very genuineness of the hukumnama has been questioned.
Right.
And
right.
secondly, my lord, the lordship may kindly come to paragraph 22 and 23. There are 4 major grounds on which the claim of the petitioner has been rejected, my lord. Paragraph, my lord, 22 and 23. Here, my lord, at that point of time, the Orissa, if lordship, section 3(1) of Orissa Act 1 of 1948 prohibited alienation of communal forest and private lands. So, notwithstanding anything contained in any other law for the time being in force or express or implied agreement was subject to the provision subsequent to, no landlord shall, without the previous sanction of the collector, sell, mortgage, lease, or otherwise assign or alienate or convert into rayati land any communal forest or private land or create occupancy right therein. But this provision was also not followed.
As far as the Forest Conservation Act, I don't see how that applies.
My lord, Forest Conservation Act came in the year 1980.
That's right, and this happened much earlier.
Yes, my lord.
But that act will not apply anyway.
Because the hukumnama was granted in the 1949. So
right.
This act was enforced by them at that point of time. Now, even if the landlord assigned the lease in favor of the father of the present petitioner, my lord, then he should have followed the with the approval of the collector. He should have granted he should have transferred the land in favor of the petitioner, my lord.
Yes, Mr. Mishra.
Now, my lord, may kindly see these paragraphs which have been read are from the suo motu order of the Board of Revenue. Now, my lord, my question is very simple: that can they go beyond their own revision before the collector? Now, my lord, may see what the collector holds. Their prayer before the collector was never that these are all forged documents. This element of forgery, these Xerox copies.
No. See, the member Board of Revenue is not precluded from calling for and looking into the record.
My lords.
Looking into the record, he found that there are only Xerox photocopies.
My lords. Now,
and he's wondering how could you make Xerox copies in 1975? There is not a single photocopier.
Now, there, my lords, it appears that these were all produced before the collector in 1998, because that's the reason why in the second writ petition, the originals have been called for. The State Council has been directed to produce the originals before this court. Now, I was checking up, my lords, they have the photocopies. The original records of the collector's revision would show, because the collector repeatedly reflects in its order that certified copies have been produced before me. Now, if my lords would see running page 64, and then 65, in running page 65, the collector records that certified copies of the entire case record of reclamation so-and-so, etc. have been produced. Then he again refers to them and goes by the Ramdhani report, which says that the Zamindar of Nagra, he was entitled to give these hukumnamas as per the orders of the Board of Revenue. All those clear findings are there. It's an elaborate order that my lords would find at running page 69. Running page 69 towards the middle, the OP has produced 2 sets of certified copies of reclamation case number so-and-so in this court. Further certified copies of reclamation so-and-so are also filed. This goes to prove that reclamation case number so-and-so was duly registered and order was duly passed and record was available for which certified copies were issued from one office of the SDO Panposh in 75 and other from Tahsil office so-and-so. As such, the contention of the petitioner that the hukumnama is illegal cannot be accepted. The certified copy is presumed to be corrected under section 114 of the Evidence Act, so long as the contrary is not proved. So what was certified copy in 1998? In 2008, it conveniently became a Xerox copy. And then these allegations of fraud and forgery and entire thing is set aside. We had produced certified copies. Now, if they are doubting the integrity of the Tahsildar in 79, this is a case where the first order in favor of this person was passed in 79. The integrity of that Tahsildar is doubted. 91, that Tahsildar is also corrupt. Second Tahsildar is also corrupt. The collector also is corrupt. That means they are presuming so many things, my lord. This is completely, a person granted a document in 49, they misplaced the records. And then the onus is on us to prove. We produce the certified copies before the collector. And that has been reflected. Now the grounds before the collector, can that be given a go by? And can a third case be made out in this manner? And my lord has seen, for all considerations before the Board of Revenue are not germane to the issue at hand. Forest Conservation Act, not applicable. Section 5, it's not a case under Section 5. So where's the requirement of confirmation by Board of Revenue?
Through the father's claim under the Hukamnama.
Yes.
That's how Section 5 is attracted.
No, father was granted in 1949.
Right.
The vesting took place in the year 1952. So it's not a case of 46, but in 52, the vesting took place. So that is the reason why the Tahsildar and the collector, both of them have recorded in favor of the petitioner, saying that it was a question, if my lord saw the order of the collector, they went before the collector saying that the assessment of rent is incorrect. So the tenancy was presumed. Now, once it's a case under Section 8, the other prerequisites of Section 5 were not required.
Mr. We just read that you claimed it through your father, who got it through a Hukamnama.
Yes.
And there is no Hukamnama. That the tribunal finds there's no Hukamnama at all.
That is after, my lord's 58 years. That the Xerox copy he is not believing, but all that was produced before the collector. Now whether they had called for the original records of the collector or not, that is for them to show. Now Xerox copies, it's a suo motu revision, my lords. So they themselves take it up and call for the record. So it is between the Board of Revenue and their own officials. We are not privy to what comes before them, my lords.
All right. Anyway, we'll all reserve orders, sir. Orders reserved.
Now, one thing, my lord, may kindly see that we were not given any opportunity to contradict. If they come to a conclusion that these are prima facie forged, the person should be given an opportunity to contradict. That these appear to be forged, kindly give something. That is not there. The basic suo motu order order which was invoked under 38B, that starts with the premise that this is a case under Section 5. Now, a counsel on behalf of the present petitioner appeared before the Board of Revenue, gave a note of submission. They are all there on the records, where he specifically raised the ground that this is not maintainable and it need not be approved because it is not a case under Section 5. that contention also has not been taken note of by they have went on a tangent, my lords.
All right. Orders reserved.
This judgment I have given of my.
All right.
Special Vehicle List item 45.
No, please dismiss for observation.
Special Weekly List item number 46.
May I please, your lordship? Order. Writ petition against the order passed by Lord and Orissa Administrative Tribunal that rejected the ground of the petitioner on two grounds. Before that, I want to draw your lordship attention that in way back 1981, he was appointed as a peon in the school. And he was not allowed to join in the attendance register. He approached this honorable court in 91. And this honorable court was directed to consider his representation to the ex-CI, which is now DO.
What is his age now, sir?
Now he has crossed the...
Then what is the point of all this, sir? The petitioner having already crossed the age of superannuation, it is not possible to consider the grant of relief prayed for by the petitioner. The petition has become infructuous and it is disposed of as such.
Special Vehicle List item 47.
appearing for opposite party.
None appears. This is non-possible.
Special Vehicle List item 48.
May I please? The petitioner availed a house building loan from the Capital Housing Urban Cooperative Society of rupees 1,60,000. And a notice has been issued which is under challenge, my lord. That is at Annexure 3. And thereafter, the opposite parties had taken a decision with regard to settlement of a loan under OTS scheme. Kindly have a glance, page, my lord, Annexure 7. Annexure 7, page 13, my lord. That is pending with them.
Who is for the other side, sir?
Annexure 7, page 13.
Sir, who is for the other side?
That is, my lord, some notice was issued, my lord. And they have not filed the counter. They have already appeared, but they have not filed the counter.
You see, the challenge in the present petition is to demand notice dated 30th November 2010 issued by the Capital Cooperative Housing Limited. It's a state undertaking.
That is a register of cooperative society.
No. This Capital Urban Housing Building Cooperative Society. Is this a state society or a private society?
That is state society because it is coming under a register of cooperative society.
No. Sir, is it a private entity or is it a state entity?
Might have been registered under the
everything registered does not become a public entity. It is a
Annexure 7, they have already taken a decision.
Sir, are they a public entity or a private entity?
Because my lord, Ashton Register Cooperative Society is coming under the state.
So that Annexure 7 is not a letter addressed to you at all.
Because it is a, my lord, it is a matter of release of additional relief for without the interest. LIC has released 98
It has nothing to do with your loan, sir. Annexure 7 has nothing to do with your loan.
Because it is a for number of loanees, not for particular.
This entity is a private entity, sir. It's not a state entity. No writ petition is maintainable. You say no writ petition is maintainable as far as opposite party number 1 is concerned, which has issued the impugn notice, demand notice, since it is not a state entity, leaving it open to the petitioner to avail other remedies that may be available to the petitioner in accordance with law. The petition is disposed of. The interim order is vacated.
This is a Vehicle List item 49.
Item 49 can take after launch, man.
Why?
Mr. Author in election, another report, man.
We'll just pass it over, sir.
This is a Vehicle List item 50.
None appears dismissed, non-prosecution.
only pass over. Item 49.
And it taken after launch, man. That's why I'm saying.
He's seeking re-engagement as a driver. He's now 59-year-old.
Come back.
My lord, I may be pardoned to make a mention. Item number 49, which was just before my lord's rising to for before lunch. There a copy counter is being served on me by the opposite party 3 and 4. And I believe that this is a single judge matter. Will my lord will hear it?
All right. Constable petitioner states that this is a single judge. For the appropriate bench. As per roster.
This is that matter which I was not mentioning. The petitioner is a 59-year-old. He's
This
seeking
is a single
re-engagement.
judge matter. Can you hear me?
Right. Doubt.
This High Court currently is coming. Second May.
Weekly list item number 25.
Please, ma'am. NCL has appeared today.
Yes, I have appeared today and filed my counter and as well as IA for modification of the order, Millers.
No, what happened? Did they supply the rakes?
I'll tell you, Lordship. 22nd.
Even if Millers, he has not entitled to one rack also. Millers, I have mentioned in my Millers counter, Millers, Miss Case Millers, IA Millers. Lordship, see my IA.
Where is the IA?
The copy has not been served on me, Millers. Neither counter nor the. Just now they served me the copy.
Let's see paragraph 4 of my IA Millers.
They're not making rakes available.
My lord,
rakes are not available.
Miller, racks, Millers.
Rake is rack or whatever you call. Rakes are not available.
Racks, Millers, railway and petitioner will arrange that racks, Millers. Millers, even if Millers is quantity taking into the annual quantity, Millers, targeted quantity, taking into 100%, he is not entitled to Millers one rack, rake, Millers, one racks, Millers. So because Millers is taking, he has agreed to take coal from road in 5,000 and in NGR system 5,000 Millers and in railway Millers 3,000.
1 minute. Let us read 1 minute.
Lordship, see.
Let us read 1 minute.
Yes, please.
What is NGR?
Metric tons.
Okay.
No, I don't understand. Unless the order is modified, public would suffer, meaning what? You say unless the order is modified, public will suffer. That's what you're saying in para 9.
Because I will explain, Millers. Because we have supplying the coal to power sector millers. Power sector, and those who are millers generated power, and it is end use of the consumers millers. If millers,
what is the modification you want?
Millers modification millers to the extent millers, your lordship directed to the 4 racks millers. Millers, he is not entitled to millers 1 rack even if millers. So your lordship modify that.
No, you are not supplying rakes.
Millers coal millers. If millers 4 racks.
Your Mahanadi Coalfields Limited.
Yes,
what have you to do with the rakes?
Millers 4 racks coal means millers. It is 16,000 ton miller. His entitlement is 13,000 something per day millers.
Who are, we never said you have to give him more than what he's entitled. We never said
millers,
that.
At the end millers, I have to give coal millers.
No, we didn't tell you to give coal more than what he's entitled. We never said that.
4 racks coal means millers, it is 16,000 tons millers.
We are not going to haul you up for contempt because some 3,000 tons fell less. Per rake, how many?
16,000 millers.
Per rake.
3,500.
16,000.
Per rake it is.
Per rake you can't carry 16,000 tons in one rake, sir.
No. 1 rack 4,000 tons. And 4 racks millers around 16,000.
Sir, if he's entitled to whatever he's entitled to, yes. If you fill up 3 full rakes, what does it come to? 12,000, correct?
Millers.
And the 4th rake, you will put 1,500.
That's it.
No millers.
That's it.
What is no? How will he carry the remaining?
Millers, 1 rake is around 4,000 tons.
Correct. He's entitled to 13,500. My arithmetic is very weak, sir. I admit.
13,000 coals, 1,000 ton road coals. He has 3 modes millers. One is road mode.
How is it affecting public? How are you affected, sir? I don't understand. You are ready to supply him 13,500?
Yes.
Are you ready to supply him 13,500?
Millers, 13,000 is the 100% because as per our letter millers, it is a 60% because due to the supply in the power sector at the 100 son millers, due to the supply of the we are reduced it to the 60% coal millers.
You never said that till now. I asked you for the first time. You're telling me.
Millers, I have mentioned in the counter millers. It is a 60%.
That is only the trigger level, millers. That is only the trigger level.
At trigger
and they are
level,
auctioning the balance. Balance 40% they are auctioning, and NALCO has bought. NALCO, which was supposed to get it from MCL, now it is public sector company is forced to buy an auction and also forced to buy imported coal millets. Will sink. This company was never set up. The entire arrangement was Bharatpur and MCL was nearby. So that is why in 82 millets NALCO was set up. Proximity, that's in the project report, and there was a unilateral assurance by the Coal India Limited that we will supply. On that basis, NALCO was set up, and on that basis, investment was made. The company came up. Now, for them to say that we are prioritizing the power sector.
Anyway, sir, NALCO should speak.
Yes.
Mallets.
The figures. Furthermore, this PIL is not maintainable on behalf of the officer association.
I know.
Lordships, there is an affidavit on behalf of NALCO which you just filed it. Your Lordships, may I just,
I have not received copy.
I understand because the matter was called up at 2:00 instead of last matter. Your Lordships will look at para 3. Lordships, the affidavit is here. Your Lordships, the affidavit is here. Your Lordships, look at para 3 of that affidavit.
Yes.
Your Lordships, we basically require 18,000 metric ton coal per day to generate that 900 megawatt power supply at a CPP plant, Your Lordships. This makes us self-reliant. Therefore, we don't depend upon the grid. If this CPP stops, the smelter plant stops. Your Lordships, para 4 says 460,000 metric ton aluminum I produced annually. That's one aspect, Your Lordships. Now, Your Lordships, what really has happened is from June, Your Lordships, that's also there in my affidavit. From June, Your Lordships, will kindly look at para 15, page 6. What's my agreement with MCL? Para 15. Your Lordships, I have two agreements with MCL. One is the fuel supply agreement, which is 29/4/2028, which is till March 2023. Under which, Your Lordships, I am assured 47,16,480 metric ton. What they have done is they have reduced it to 60%. Below 60%, they will be liable for penalty. So they brought it to 60%. So I am without 40% anyways. Then, Your Lordship, we have a bridge linkage agreement, which is supposed to supply me 12,900 metric ton per year. That has also got reduced to 9 lakhs metric ton. Your Lordships, plus we have also participated in our e-auction para 17. Your Lordship, which is a very costly method, which is only a one time to meet if there is a sudden need, Your Lordships. That shortfall also, Your Lordships, they are yet to provide. And again, that problem is also the rake problem. That being the situation, Your Lordship, look at para 19. Your Lordship, the supply of coal drastically reduced from June 2021. Then NALCO started purchasing power from grid, Your Lordships. But that grid supply now has stopped from 33/2022. So Gridco cannot supply us power. Lordships, that is why we had to fall back upon our coal reserves. But because their supply is slow, because of two reasons, they themselves have directed their railway siding authorities, don't allocate more than 6 rake to non-power sector. And I'm not the only one in non-power sector. I require 3 rake, 6 rake for all the industries. So that is why, and they have directed. One hand, they say, I have to arrange the rake. In second, that letter is there in the writ, Your Lordships. Your Lordships, the present situation facts figure I will give, para 20, Your Lordships. Your Lordships, there is an underlying portion in para 20. Your Lordships, as on 24/4/2022, my coal stock is 1,07,178 metric ton. This will go for 2-3 days only. Your Lordship,
after we passed the order, what did you get?
Your Lordships, what we got is again at the last paragraph, Your Lordship, in that affidavit. Para 26. Lordships.
One on 23rd, 4 on 24th, and 3 on 24th.
Lordships. But we are daily consuming because we don't have any backup. And the amount which I showed, Your Lordships, 60% is carpet coal, which means it's not usable immediately. So only 40% left. Your Lordships, actually in a critical situation. And once my smelter plant goes, I cannot revive for 2-3 years. And Your Lordships, I have a 3,500 crore export obligation. I get equipments free of cost, and 6 times I'll pay the nation, provided I'm able to meet my export obligation. If it shuts, I will not. I'm definitely to become sick. And my situation is critical because of the joint connivance of the railway as well as MCL not to supply.
No, not for connivance. Don't use such strong language. See what is happening. I'm sure you're aware. I think power plants all over the country are in a crisis. At least the thermal power plants definitely are in a crisis because they don't have enough coal.
That enough coal they don't have because the import has become costlier.
MCL is under pressure to supply a minimum quantity. This we're doing through judicial order. Central government probably has given them instructions they should supply to power companies. Because I wouldn't be surprised if very soon NTPC or somebody comes here saying that we are not getting enough coal.
Your Lordship, that's exactly what we wanted to clarify. NTPC and all these companies, they come under the assured zone. They do not face the problem. Today we face the problem because of these independent power plants who were relying on the international exports where the cost has gone up. But our CPP and the boilers and Damanjodi are made only for the indigenous coal supply. The notification of the government is also there. That notification was not a restriction on them. In fact, they have been saying we have enough of coal. The problem is that the direction that they have given to the railway authority, their own siding.
In turn, the direction is because of some other direction to them, the central government.
That central government direction is, it doesn't say so.
Anyway,
Lordship, that central government direction is there.
They have also coal
If the Lordship permits me,
they have also coal block.
The independent
Government of India allotted coal block, but he has not operated.
1 minute. Lordship may permit me, Manoj, to intervene for a second, Manoj. The IPP, the independent power producers, after supplying to the grid, government grids, Manoj, whatever is the surplus power, they are selling, Manoj. I'll file an affidavit to that effect. They are selling at an exorbitant rate to the private company. So they are doing business at the cost of coal meant for a public sector company. That coal is not being granted. That 40% coal is shortage. As such, it is a short supply, and then that is supplied to them. The independent power.
He says
maximum private players in that zone. Malad.
He says NALCO has a coal block.
No, NALCO it's not functional. That's why we have a bridge agreement. The bridge agreement is that till the time that does not become functional, which will take by 2023, it will become functional. That bridge supply was at 9 lakh metric ton. So that arrangement is there in place. So he cannot just bank up on that.
There can't be business.
I mean, the whole thing is, Your Lordships. End of the day, we may fight anything, but this is a fact that 2 days, and if this 2 days smelter goes down,
but NALCO is a central government PSU, right?
Lordships.
So MCL is a central government PSU.
That is a settlement provision also in the FSA.
That probably would answer Your Lordship's question why NALCO was not there in the first place.
Then PIL is not
Now, what is
then PIL is not maintained.
Your Lordships, I got two letters on board, Your Lordships, which we have specifically written to.
Yes, Mr. Pari.
My lord, my whole.
I'm going to order. I'm going to order mediation by the coal secretary. Seriously, let the coal secretary and power secretary sit together with the MDs of NALCO and MCL.
Yes.
Let the four of them meet, sir. Can they meet today evening?
My lord.
Secretary coal, secretary power, MD MCL, MD NALCO. Let them have a virtual meeting today.
May I submit something, my lord?
That's the easiest solution, sir. Any amount of judicial orders, all this will off. They're only doing band-aid.
My lord,
today's urgency, tomorrow's emergency will be passing orders.
My lord is absolutely correct that about the power sector issue is concerned, my lord.
No, both are public sector, central government PSU, sir.
Yes. All are a political undertaking. What I am saying, my lord, whatever affidavits they are filing, suppose MCL is coming with his grounds, the NALCO is coming something, all are a government undertaking.
Correct.
So what my lord is suggesting, the lordship may fix to day after tomorrow. In the meanwhile,
we'll fix the hearing day after tomorrow, sir. Let the meeting happen today or tomorrow.
My lord,
today evening or tomorrow morning.
I am saying day after tomorrow, my lord. Both the secretary is required to be seated is correctly lordship have taken decision. And I convey all the secretaries, let them interact themselves because Lordship is the peculiarity is the minister is one. The cool and the minister of mines are the one minister, my lord. The second right. Two different. Though ultimately these materials go to them, and apart from the railway will transport. There is no issue at all.
I don't think railways are going to raise any problem, sir.
Yes,
If
yes.
Railways can always be called for that meeting.
But there is a
My
problem.
friend would
with
stand
railway is
behind him
that-
for that.
But railway problem is that what I've heard from them also, there is a railway board has a instruction that they will transport the coal to the power sector by reducing the supply to the NALCO or any other sector. There's not.
The problem is the criticality. See, what happens is
Yes,
once a
absolutely
plant is functional,
Yes.
if you don't have a critical level of function, the entire plant shuts down, sir.
My lord.
And a shutdown plant, if it has to revive, it will take some months to go to the critical production.
Years, my lord.
So, my lord, may
In case of
tomorrow.
smelter plants, it will take at least
Last
2
time I
years.
fixed
2 years, is it?
2 years.
Yeah, even the refinery plant can't start immediately.
Yes. No, there is no issue. That day after tomorrow, both the secretary will interact themselves, and they will along with the interaction with both the MDs, CMDs, and metro can be certain.
Sir, every day will be very critical. Why I'm saying this is, if you get pushed to Thursday and Friday, again same, because this again coal stock will last only for 2 more days. By Friday, they'll again be back in crisis situation, sir.
Yes. There is
So let them meet tomorrow evening.
Yes.
Maximum tomorrow evening. If not today evening, tomorrow evening. Let them meet tomorrow evening.
Yes. But in the meanwhile, they should serve all the copies.
Everything, everybody will
I
get,
can
sir.
make it scan and send to everything to the.
All of them know the case of each other. Actually, they've been doing this for some months now.
In the meantime, the supplies may continue. my lord.
The new entrants are the 2 of us. They all know each other's case for last 1 month.
But
In the
my
meantime,
lord,
the
I
supplies
hope
do
and
not be
trust my lord
interrupted.
will settle all problem. That should be permanently settled.
No, my friend has been a big help. In fact, it was his insistence and intervention which got the railways to turn around and supply.
What are you? Who are you for?
Lord, we are appearing for the UCCI, Utkal Chamber of Commerce, which is taking up the cause of this MSME units. As the downstream industries of
NALCO
and Vedanta both.
400.
Okay.
So there are about 400 units, which will again, because they're completely dependent upon them.
Cascading
they will shut
effect.
down. Cascading effect. They will all shut down.
So
Fuel is only for 4-5
The Damanjodi is almost nil, your lordships. And if alumina doesn't get produced over there, then again the smelter plant gets hit. So we're really in a bad situation.
But in fact,
And
Vedanta
so
actually
many
have got
workers
two
just
units.
go out.
One is Jharsuguda and one is Lanjigad. But the fuel left is only for 4-5 days.
Right.
And their size of the
Whom are
plant
you
is-
for, Mr. Mishra?
I am also for the MSME units, but the association who has come on the line, they are going to be severely affected actually by virtue of this.
I see.
But our upstream unit is the Vedanta Aluminium, not the NALCO only.
Right.
Because that is a 3 times bigger plant. And from that, in that area, remote areas.
That is not before us. So
No, my lord, the
before
other
you
2
also
rate
not.
applications. The other 2 rate applications which we have filed and morning your
Many
lordships
industries
called
are
for
coming
that.
forward for their coal. Many industries are coming.
There are 2 rate
This
applications.
power sector is a first priority than others.
And which is the other one?
Lord, 101.
33 power sector has at stake, my lord.
All right.
Less cost.
10424.
My lord, even if they give it at the trigger amount, which is 60% also, there can be a sustenance. It cannot be a thriving, but can be a sustenance. That also, even though they are loading almost about 95 rakes to 100 rakes in a day, to the non-power sector, it is only 3 to 5.
And if your lordship sees it other round, if our CPP becomes functional, in fact, the demand of power supply gets reduced.
Naturally.
Because we require about 3,750 megawatts, which we are captively generating to Vedanta, and then the lower stream industries are benefited because of that only.
And even our SPP co-produces power.
Yeah, that's right. Surplus power goes back to the grid. Correct. You see, affidavits have been filed both by Mahanadi Coalfields Limited, bracket MCL, as well as NALCO, placing on record the respective concerns regarding supply of coal to NALCO's smelter plant at Anugul, right? And how does this tie with the Damanjodi
And also
alumina
Damanjodi.
refinery?
Lordships.
How does this tie up with the Damanjodi refinery?
Damanjodi refinery has tie up both with MCL and Northern Coalfields also.
Lords, that is not an issue here. Lords.
No, Lordship, but we need even if rake has not been supplied. No,
yes.
See, we can be hyper technical, but if the Damanjodi stops, it stops. Your Lordship, para 25, Your Lordship.
Of your affidavit.
Yes, Your Lordship. Second paragraph. Similarly, for SPP at Damanjodi, sustainable daily supply of at least one rake from MCL, SPP, Talcher, Coalfields, or MCL is required. However, this is only possible if the East Coast ensures one rake daily allocation to NALCO for supply to SPP plant at Damanjodi from MCL. Further, if rakes are not getting allocated from Talcher Coalfield SPP, then the same can also be supplied from IB Valley Coalfields of MCL at SECR Bilaspur of Railways, where SPP has 32 pending rakes. And a Block B silo GCMC siding of Northern Coalfield.
No, CPP is captive power plant.
No, Your Lordship, no, this is SPP. In Damanjodi, you have SP, steam-based power plant.
Oh, what is that?
Steam-based power plant.
Steam-based.
There are two uses of this. This co-produces power. That steam itself is required to change bauxite to alumina.
I see. All right.
Of Mrs. Northern Coalfields, Singarura Coalfield. This is also under MCL, right. Where SPP, Your Lordships, all this rake are pending.
Correct.
They have not arrived till date.
All right.
And we have made payments for it.
Right.
Millards, Onugul plant is only.
And also, my lords.
Onugul plant is 23 to 25 kilometers distance from the my mines, Millards. Millards, he may take Millards by road also. Millards, they have agreed to take a road. Millards, the Lordship para 3 Millards.
Your Lordships will see actually Angul. Smelter was built in Angul. Because Your Lordship, it was the pit is 25 kilometers, 30 kilometers distance. We had a merry-go-round system of railway system operating between these two pits, between NALCO and between their pit, which was functional and doing well and assured 18,000 metric ton capacity. Because MCL has not been maintaining it, what has happened now? The capacity has come down to 6,000 metric ton. They are saying about roads. For one rake is equal to almost 80 truck. 80 truck I'm going to get within, all these villages. And Your Lordship, it's completely a dangerous thing to move my 80 trucks within a running plant. It was never made for a road. Road was only for an emergency. They are now insisting just for road.
They have agreed to take 5,000 tons coals in the road and 5,000 tons MGR. Rest
what
of
is MGR, by the way?
Not merry-go-round.
Merry-go-round.
Not only that, my lords.
They have agreed, Millards. They have agreed.
The collector has threatened to stop.
that document. That is a meeting between
We tried, the NALCO tried taking by road.
There are other petitions before us on this carrying of coal lorries on roads. So the roads get destroyed.
The collector, my lords, has issued a warning.
There is a coal corridor.
That either you stop it or I'm going to pass an order to stop it and seize those vehicles. That is the
coal corridor
state administration stand.
Anyway, it's okay. Let them resolve it at that level.
My lords, let the interim arrangement continue till the resolution. Let it continue.
All right. We say pursuant to the order passed by this court on 22nd April 2022, East Coast Railway. Who's appearing for East Coast Railway?
My friend,
Mr. Paddy.
Mr. Paddy.
All right. Yes. Has supplied one rake for carrying the coal from the pit head of MCL what is the name of that mines?
Bharatpur and Talcher.
At Bharatpur, is it?
And Talcher. And also Talcher.
At Bharatpur and Talcher. 4 rakes on 24th April 2022 and 3 rakes are meant for today. That is 25th April 2022. Let's stop. Ms. Famirath, learned counsel appearing for NALCO, points out that the coal supplies have been reduced to 60% of the contracted demand. And NALCO is in fact making up for the remaining coal supply by purchasing at a public auction 9 lakh metric tons per year.
That's the bridge agreement.
These pillars, that is.
No, what is it that you're purchasing in a public auction?
Your Lordships, that's the e-auction, but that's a very inconsistent amount.
As per the bridge agreement, Millers, 75% is and best efforts basis, Millers.
Yes, so that comes down to 9 lakh. That comes down to 9 lakh.
Bridge agreement is depend upon the availability, and that is 75%.
Anyway, we will not go into all those details right now. You see, she states that
is not connected with FSA.
Smelter plant totally depends on its captive power plant, (CPP), which is a thermal power plant dependent entirely on coal supplied from NCL. Stop. If the CPP does not generate enough power to keep the smelter plant going, NALCO's smelter plant itself will have to shut down. She points out that NALCO has export orders which have to be met and which has the potential of generating huge revenue for the country. So it is therefore earnestly pleaded that MCL should be asked to restore the full supply of coal as agreed between the parties, so that the smelter plant does not shut down. Right now, the stocks available with NALCO can keep it going only for 3 more days.
3 more days.
3 more days. Paragraph. Mr. Monti appearing for Mr. Devraj Monti appearing for MCL, on the other hand, seeks a modification of the interim order passed with this court on the ground that MCL should not be compelled to supply only to NALCO through rakes, as there is a requirement on it to supply coal also to power plants. He urges that NALCO should be asked to lift coal as per the reduced agreed quantity by other means of other modes, namely by road and through the single quotes merry-go-round, unquote, which is an exclusive rail line.
Yes, dedicated rail line.
Dedicated rail line connecting.
Not fully functional.
Not fully.
Connecting
Yes,
the
yes,
pithead
yes.
with NALCO smelter plant.
Frequent breakdowns.
Both Mr. Sudhir Palit, learned counsel appearing for the petitioner, as well as Ms. Rath appearing for NALCO, informed the court that the MGR is not fully functional.
Functional is taken.
And transporting by road would be both cumbersome and hazardous. Paragraph. Meanwhile, the court has on its board today 2 more petitions. Writ petition civil 10423 of 2022 by the Utkal Chamber of Commerce and Industry Limited, and the other writ petition civil 10424 of 2022 by the District Small Scale Industries Association. Both petitions espouse the costs of the medium and small scale
My lords, with your permission,
manufacturing enterprises, right? MSME. Yes.
If my lords may see the IA in these 2 petitions, it
Yes.
will be very clear. If my lords may come to prayer number A in these IAs, it will be
Yes.
very clear the quantum of coal which is required for a
Yes.
company the scale of Vedanta, which is, as my senior rightly pointed out, 3 times the size of NALCO. And my lords, even with Vedanta Limited, they have 3 to 4 days of stock. And my lords, MCL has reduced this.
The point is, Mr. Verma, Vedanta Limited is not before us.
My lords, it's a party. It's been made a party in this petition. It's OP.
I know. But the same story. You see, NALCO also not coming forward. One can understand because they are PSU versus PSU. But there's no reason for Vedanta not to come forward. It's all right. We'll just note the fact, supposing because of the MSMEs who are likely to be severely affected in a cascading manner if the major alumina and smelter plants cease to function because of shortage of power supply.
Shortage of coal supply.
Shortage of coal, which in turn
is to be generated by
that's
themselves.
a shortage of coal supply, which in turn will affect the power supply. Paragraph. Since the essential dispute concerns two central government public sector undertakings, that is MCL on the one hand and NALCO on the other, and also involves the participation of the railways, which is the third central government undertaking in the picture. The court considers it appropriate to direct that the Secretary Power, the Secretary Coal, and there will be a railway board which is involved, or
Railway board, the chairman cum CU is the authority.
no, which will be the authority in the railways which will take a decision here?
Railway chairman cum CU.
The chairman railway board.
There's an executive director coal in the railway board.
The chairman railway board will sit together with the managing directors of bracket MDs of MCL and NALCO not later than 6 p.m. tomorrow, that is 26th April 2022, to find a way of resolving the crisis, to ensure that the smelter plant of NALCO at Angul.
Secretary of Mines should also be there. MCL and NALCO both under Secretary of Mines.
Okay, and Secretary Mines.
Well, the power secretary has no role to play. Only my mine secretary and the coal secretary.
Power secretary would have a role, Manal, because of the IPPs and their private sale to private companies.
Let the power secretary be there. See, he'll give them the correct picture. That's important, Mr. Pari.
That picture should.
Otherwise, it won't be a complete discussion.
Right.
Then they'll pass on the buck to the power secretary.
Correct. That's what.
That's right.
And the secretary Mines also, you can add that. Not later than 6 p.m. tomorrow, that is 26th April 2022, to find a workable arrangement to be put in place so that the smelter plant of NALCO at Angul is not pushed to a critical phase.
And also Damanjodi.
Also Damanjodi.
And okay, the smelter plants of and the refinery of NALCO at Angul and Damanjodi are not pushed to a critical point of shutdown. The minutes of the deliberations will be placed before the court on the next date. List on Friday at 10:30 a.m.
Yes, yes.
All right.
In the meantime, the interim arrangement to continue, my lords.
Oh, Friday, I'm not here. It'll have to be tomorrow. It'll have to be Wednesday. It will have to be Wednesday. Because Thursday is a holiday.
My lords. Friday 10:30.
No, I'm not here on Friday.
My lords. Wednesday.
It's too.
The interim arrangement to continue, my lords.
Next Monday on 2nd, my lord. Next Monday on 2nd.
No, then the interim arrangement will have to continue till then, Mr. Pari.
MCL is not hurt. They're under obligation to supply us the coal, my lord.
Let it come on Wednesday. You can take it up even in the afternoon at 2 p.m. on Wednesday.
All right, man.
Wednesday at 2 p.m.
Millards, entry management are there
To continue,
entitlement under FSA, Millards. So let's clarify that.
Sorry?
Under FSA, their entitlement may be Millards entry
No,
management.
that will lead to unnecessary confusion, unnecessary interpretation. Millards is trying to
Till then, the interim arrangement in terms of our order dated 22nd April 2022 will continue.
Oblige.
Mr. Jateshwar Naik is appearing with me. Let me reflect along with me, Mr. Jateshwar.
All right, Mr. Parekh.
Leave to file rejoinder, Millards.
Whatever, we don't have to give you that permission.
My sincere request to all of my
Consider your
friends.
petitions after this comes. If a solution is found, then you may be taken
The
care
matter
of.
can be resolved on Wednesday.
Because again, our
only 1.8 rakes per day.
amount which is left is about 4-5 days. So since your lordships are taking up day after tomorrow, this matter can also be resolved with that.
Correct.
And till such, because as my learned friend even suggested from MCL that triggered amount,
right?
We are also, if they can assure that also in the interim, we are also in a sustaining.
They have to arrange rakes or other modes, Millards.
Mr. Pari will arrange to communicate by email this evening itself this order to the concerned.
Yes, I'll communicate today itself, my lord.
All right.
After uploading, I will just take print out. But my sincere request to all of my friends that let's serve the copy, whatever appeared their file.
All right.
All the record, then I can also convey to the concerned secretaries in this regard.
All right.
But if your lordship looks at the interim applications filed in the present two writ applications, but there we have said the minimum quantity of rakes to be supplied to us. But for the purpose of maintaining the standard, actually we are going to last it for the 3-4 days or more than 4 days. It cannot be there. It will be in a critical position, my lord.
No, again, you see the point, Mr. Mishra, is those entities would have to come forward. I'm saying you are dependent on NALCO, right?
No, we are Vedanta, my lord.
That's right. And Vedanta has not come forward. So let's not.
A lot of private companies there, they can demand lordship, whatever or lordship path, let them continue till Wednesday.
Right.
After we'll examine what to do. Not only Vedanta, so many companies there.
Correct. Yes. All right.
As per the statement of the MCL Council, my lord, if they can supply as per the FSL agreement, so that will do also, my lord.
Right.
As per even the trigger amount, what the MCL Council say. There's the bare minimum, which is they have all, they themselves say.
Anyway, let's see day after tomorrow.
Not 100% even that 60.
Right. Yes.
Weekly list stress admission item number 1.
Yes.
Stress admission item number 1, weekly list.
None appears dismissed from purpose.
Weekly list item number 2.
So kindly pray for a short adjournment.
No. Tell us what the matter is about.
Sir, it is a PIL matter of 2016 due to my seniors.
No, tell us what. Go beyond that, please. Those two are obvious. It's PIL, it's 2016.
So I got file 1 hour before.
Sorry?
I got the file 1 hour before.
1 hour is enough, madam. 1 hour is more than enough. Let's come to the prayer class. Come.
Okay. So this is a PIL matter of reconstitution of the Gram Panchayat. Sir, we make a representation in Annexure 1 since the year I'm taking that 23rd 5th 2016 before Arun Kumar Shah, Honorable Minister of Panchayat Raj Department, for reconstitution of a Gram Panchayat name as Lordship.
See, the notification was issued in June.
Yes, Your Lordship.
Your representation is May. So after the notification, you have not made a representation. You have to make a representation after the notification.
Yes, sure.
You say counsel the petitioner, you make a fresh representation. Counsel the petitioner seeks leave to withdraw this petition with liberty to make a fresh representation against the notification dated 29 June 2016 to the concerned authorities in accordance with law, and after following up on such representation, seek appropriate remedies. This post office withdrawn with liberty is paid for. All right.
Weekly list item number 3.
May I please, Lordship? In the second round litigation, my lord, to that extent, my lord, may kindly see, initially, your lordship passed by annexure at page 18, my lord. Your lordship was directed, may I please, my lord? In response to the direction given by your lordships on 14/7/2021, directing to the collector, district magistrate, chairperson, municipality, Jagatsinghpur, on its merit to consider the representation behind annexure 4, my lord, after giving due opportunity of hearing to the petition of the OP number 5, and reason order be passed thereon on 4th October 2021. The order communicated to petition not later than so. If the petition aggrieved by such decision, it will open to them to seek other appropriate. Then thereafter, may I kindly see the order after the by annexure 5, the relevant portion is at page 23, my lord. This is the order passed by the collector, keeping in view the order which has been passed by your lordship, my lord. Relevant portion, my lord. Hence, in the third paragraph, hence I do hereby directed to the executive officer Jagatsinghpur to take immediate necessary steps to repair or renovate such road which is used as approach road by the villagers, and also access the cost of damage and same be recovered from the OP number 6 under OPDR Act. Further so and so direction. But in spite of the direction by the collector, my lord, the executive officer has not been carried out till date, my lord. To that extent, my lord, we have also made a representation to the executive officer, my lord. At this juncture, the petitioners are going to suffer like anything, my lord.
Well, notice be issued to Jagatsinghpur municipality. For the rest of the opposite party, I'll take notice.
Yeah, Mr. Das accepts notice for opposite parties.
5.
1 to 4.
Yes, my lord. Except 5 and 7.
Yeah, 1 to 4 and 6. Notice now. A notice be issued by registrar's speed post to opposite parties 5 and 7 returnable on May 11th May. So Das states that he'll have instructions by the next date from the collector.
Yes.
The executive officer, Jagat Singh Municipality, will remain present either in person or in virtual mode on the next date. List on 11th.
Weekly list for orders item number 4.
My lord, I am here for the petitioner.
The memo is taken on record. The petition is disposed of, is withdrawn in terms thereof.
Obligement.
Weekly list item number 5.
None appears dismissed, non prosecution.
Weekly list item number 6.
Hello, item 6. 2 days time to remove the defect, my lord.
Mr. Das says, Devdas states that he'll remove defects within 1 week. List thereafter.
Weekly list item number 7.
7, my lord. I have to kindly taken up any other day, my lord.
On?
Kindly taken up any other day. There is a CMAPL restoration of that due to non-prosecution of dismiss and file that application, and main writ application and other 2 writ application pending before your lordship. And in lieu of the interim order, some of the petitioner relating to this matter approach for the Honorable Supreme Court. I am submit all the documents by tomorrow and taken up day after tomorrow.
All right, list day after. List on Wednesday. All right. At the request of counsel, the applicant list on Wednesday.
Weekly list item number 8.
Your lordships, my lords, here parroting the report of the investigation department of the income tax department, the assessment for the assessment year 16-17 was reopened, and lordship will kindly see the annexure 3 at page 15.
Yes.
Investigation report has been received from the DDI T2 within bracket 3 Bhubaneswar, which reveals that the assessee has suppressed purchase of iron steel goods of 122.34 metric ton As per the information received, an action was carried out by the state GST department wherein discrepancy regarding purchase of stock was found, and thereafter, my lords, the assessment was reopened under Annexure 1 at page 9 with the approval of the Joint Commission of Income Tax for the assessment 16-17. And your lordship, the assessment was completed under in violation to their own circular by giving just 1 day's time. And I have got a judgment of your lordships that 1 day time is not sufficient. I have enclosed that circular.
So there are 2 points here.
Yes.
31.3 joint CIT.
Yes.
So that also is bad.
Yes.
That is one day time given. That is 1 day time. Annexure 2.
See, there are 2 grounds on which the impugned assessment order dated 30th March 2022 passed by the National Faceless Assessment Center, Delhi, (NFAC), as well as the notice dated 31st March 2021, preceding it, issued under Section 148 of the Income Tax Act 1961, has been challenged. Full stop. The first is that only 1 day's time was granted to the petitioner to respond to the show cause notice dated 7th March 2022 for assessment year 2016-17, for which the assessment was sought to be reopened. So, in terms of the order passed by this court,
yes, ma'am,
on 30th March 2020.
Ganesh source. Upon the copy behind. In that case, lordship set aside
2021
order and directed the petitioner to appear
in Petition Civil 33558 of 2021. Bracket Messrs. Ganesh Ores Private Limited versus Principal Commissioner of Income Tax, Sambalpur. This court set aside the assessment order in similar terms on an identical ground. Of inadequate time being given to the SSC to respond to the notice. So the second ground is that the impugn notice under Section 140 of the Act was issued on the sanction of the joint CIT. Although it was issued prior to 1st April 2021, that is on 31st April 2021, when it should have been with the prior satisfaction of the CIT. So on both these grounds, the impugned assessment order is hereby quashed as well as such, and the impugned assessment order dated 30th March 2022 and the
Annexure 3 at page 15.
Notice dated 31st March 2021, bracket Annexure 1, are hereby quashed.
And also Annexure 3 matters.
That's right. Both are hereby quashed. Yes. This will, however, not preclude the department from proceeding afresh in accordance with
Well,
right.
Much of that. We can list item 9.
May I please?
Yes.
But in this writ application, the notification, the order at Annexure 3, page 39, issued by the MCL authorities is under challenge on the ground that it goes against the RR policy 2006. In RR policy, my lord, certain procedures have been provided how the land outage or landlord will get the benefits of employment and rehabilitation.
Anyway, your representation is there, sir.
Annexure 6, my lord, the English translated copy I have given.
Or the petitioner's representation dated 28th February 2022 will be considered by the
opposite party number 7.
General Manager, Kaniha Area MCL, bracket opposite party number 7. And after issuing notice to the petitioners and giving them a hearing, the reasoned order shall be passed thereon not later than 1st June 2022 and be communicated to the petitioners not later than 8th June 2022.
Till then, that
court clarifies that it has not expressed anything in the matter. Yes.
May I pray, my lord, that till date that notification may not be given to my lord.
What notification? There's no challenge to any notification, sir.
Yes, yes, Annexure 3, my lord. Annexure 3, page 39. That is the notification. In that representation, I have prayed that that notification may be withdrawn, since it is going against the.
That will be guaranteed the final relief. Sorry. Yes.
Weekly list item number 10. Here, my lord, similar matter has been posted to 3rd of May. And your lordship have stayed that proceeding, my lords. I am giving that order. That 148A, my lords, you have to confront it, and thereafter, after hearing, then you will issue 148.
Correct.
Yes, my lords. Just few days back, lordship have passed. So identical matter is coming on 3rd of May.
Same order.
Oh, sorry. 4th of May. I'm sorry. What I submit, my lords, can it be listed after 4th of May? Because that decision will.
Or 10th.
10th, yes.
All right. All matters.
All the three.
Right.
Weekly list item 11. Much of like.
11 is a similar matter where I have challenged 148A-D order, my lords, because 148A-B has not been complied with.
Okay.
And no chance of hearing has been given. Additionally, my point is, my lords, the 148A-D order is a non-speaking order, my lords. He is now trying, my lord, I say my sources of finances, the banks and the financial institutions, my lord. He now tries to find out the source of my source. And he's saying your explanation is not satisfactory and 148 notices have to be issued, my lords. I just humbly pray, my lord, since your lordships have, since Mr. Rai's case is concerned, it was only confined to the hearing, my lords. In addition, my lord, I also challenged the non-speaking order in this 148A-D, my lords.
Yeah, but Mr. Chimanka.
Yes, Mr. Chimanka is appearing for the opposite parties.
No, should we allow it or?
No, your lordship have not allowed it. Your lordship have kept it to the 4th. And since the other matter is coming up on the 10th, this may come up on the 10th. And in the meantime, my lords, your lordship have been kind enough to.
No coercive steps.
Sorry, my lords?
No further steps be taken.
Pursuant to the notice under 148.
Right.
That's annexure 5 minutes.
Right.
My additional point would be hearing as provided under 148B as well as the non-speaking order minutes.
Anyway, that day we'll see.
Much obliged. For the moment, below, this order may be passed.
Correct.
Your lordship are keeping it to 10th.
Right. Same order.
Same.
10th.
Weekly list for admission item 12.
Please, your lordship. Lord, the petitioner before your lordship is a displaced person, my lords, whose homestead and agricultural land was acquired by the government of Orissa, my lords, in 1980 for construction of a multi-purpose project, my lords. The rehabilitation policy provided for each displaced person could either opt for allotment of 3 acres of irrigated agricultural land and 50 decimals of homestead land, or could opt for 6 acres of unirrigated land and 50 decimals of homestead land. Government had reserved, my lords, certain lands in the area for rehabilitation of these persons. And accordingly, while Annexure 1, petitioner was found to be a displaced person and he opted for 6 acres of unirrigated agricultural land besides the homestead land, my lords. He was asked to identify the land, my lords, and by Annexure 1, he identified the land. That is at page 10, my lords may see.
Yes.
The petitioner has duly inquired of the Amin and verified by the revenue inspector. Petitioner is a displaced family. He has selected the following plots for his agricultural land and homestead. These next page, my lords may see, these lands have not been reserved for any specific purpose and leasable. Petitioner is eligible for Acre 6 of agricultural land, 50 decimals of house site free of cost. Issue proclamation put upon such and such. Thereafter, my lords, the petitioner was
given possession of the land, and while annexure 2 at page 12, the Amin also confirmed the possession of the petitioner over the lands in question.
Yes.
Thereafter, my lords, the lands could not be given to the petitioner in the ROR, my lords. His lands could not be given to him. And then your lordship may see page 16, my lords may see, annexure 5. The Amin writes that as per order in lease case number such and such, I went to village Bhakarsai of leaseholder Sebak Khadiratna, inquired in his presence, found that according to Sabak map and Sabak Khatian, Sabak plot number such and such, the cultivated land and homestead land was given on lease to the said leaseholder, and provisional patta was given in 1980. The plots are in exclusive possession of the leaseholder. When compared with the Hal map and Sabak map, it was found that the lease plots have not been indicated in the Hal map. When the Hal Khata was compared, it was found that the plots have been attached in the reserve forest and area of the plots are not in the Khatian. Without correcting the lease case, I am informing you. Then he has written, when I compared, the RI has written, when I compared the lease land ROI of Sebak Khadiratna, found that that has been included in reserve forest, but leaseholder has already converted it to cultivated land. Lords, therefore I am before your lordships. And the state filed a counter also, saying that it could not be given because it is in the reserve forest. And in the counter, the state says that petitioner can choose other lands to his convenience. My lords, the petitioner was 66 years old when he filed the writ petition. Now asking him to go and choose the lands at this age, my lords, when he has already converted the land which was reserved by the state government for the purpose, my lords, my submission is that it should be settled in his name. And that is also allowable, my lords, by the government. Your lordship has directed.
The last order, my lord. Lordship had directed the government of India to file affidavit. Twice they have taken adjournment.
The government of India to file an affidavit.
Yes.
But
8/2/2022.
May I submit, my lord? In this case, twice my lord has directed and we also communicate. We are not getting any communication from the Ministry of Environment in this regard.
So what do we proceed as if they don't want to file a reply?
Ask the officer to appear in person, or it can be ignored, whatever.
You had told us it's going to be ready and it's going to be filed. That's how we recorded last time.
This is wrongly, it was might have submitted. They have given another case. Wrongly, my associate told that.
Today, Mr. Pari informs the court that it was wrongly informed to the court on the previous date that the counter affidavit was ready. He states that he is yet to receive instructions from the Ministry of Environment and Forests and Climate Change. Correct?
Yes, sir. Yes.
If no affidavit is filed on or before 20th May 2022, it will be presumed that the central government has nothing to say in the matter. List on 7th July, sir.
May I pray one thing, Lordship can reflect it when particularly the department. Lordship, either the secretary or any of the authorized person can file the, because what they are doing, they are authorizing any scientist or anybody there file, even though they are not intended to get, they are not understanding the law. Actually, on behalf of secretary, any of the competent authority can file. They are also
right.
My lords, can I draw your lordship's attention to para 8 of my rejoinder?
Yes.
Your lordship may look at para 8 of my rejoinder.
Yes.
Because the state says that they cannot do it because of the Forest Conservation Act.
Right.
My lords may see at 6 lines from the top of para A.
Yes.
After the Forest Conservation Act was introduced, state government in the erstwhile Revenue and Excise Department had by notification number such and such dated 6/12/83 framed guidelines regarding manner in which ROR is to be prepared in respect of land classified as forest land. It has been stated therein that if no forest growth is found on land recorded as any category of forest land, Tahsildar can exercise powers conferred on him by Rule 34 of the Orissa Survey and Settlement Rule 62 and change the character of lands in the ROR after consultation with the concerned DFO, who is required to give a no objection certificate within 90 days from date of receipt of requisition of the Tahsildar. The notification also empowers the Tahsildar in the event of not receiving the no objection certificate of the DFO to change the classification of the land in the ROR after expiry of 7 days of the stipulated period of 90 days, and also empowers the sub-collector to finally decide the dispute in the event of a disagreement between Tahsildar and the DFO. I have given a copy of that notification also, my lords. And even, my lords, the Ministry of Environment also by a circular says that where lands have been previously reserved by the state government for rehabilitation, those lands can be excluded. Plus, the state government, instead of doing anything, is just passing the buck on. And this old man is suffering. He doesn't even have an identity card because of the fact that his land in question is not recorded in his name.
Okay. Okay. What date is it? 7 July. 7 July. Right.
Weekly list item 13.
Before my learned senior starts, I'll request my learned senior to provide me the copy of the writ petition, because except one additional affidavit, none of the records are available.
They have lost it somewhere. I'll give it to them. I have no choice. My learned friend just indicate that.
Which writ petition?
No, sir. That 2000 4737 by 2003, and along with all writ petition which are there.
Katya states that
they have
records are
they have the copies, my lord. Not that they don't have the copies. Mr. Mahanti gave those copies, my lord. They are the ones who filed that affidavit saying that there is a consultation settlement in their favor,
correct.
And we have not preferred a revision or appeal.
Correct.
That is the one.
All right. Copy of the
whatever he wants, my lord, I'll give it, my lord. Short date,
WP Civil 4737 of 2003. Another copy of the paper book in WP Civil 4737 2003 is supplied by counsel the petitioner to Mr. Katke, learned AG, within 1 week. Within 1 week, sir?
Now, in the next 2 hours, my lord will give it. My lord may call it on Wednesday.
How urgent is it?
Well, we'll give it in the course of the day.
No, how urgent is it?
My lord, this is a land acquisition matter of 2092. And they have held themselves, my lord, they have filed an objection on section 30. 30, the state files and says that some usurpers have come in and they have taken the. Now, my lord, they say that the matter is pending before the commissioner. And then now they file an affidavit saying that this is the matter where, my lord, exercise the power of review, and thereafter, my lord, it's come. And it was recalled.
No, that I...
Any short date, any date, my lord.
Finding a date is what is biggest challenge. Can we have it on the opening, sir? We'll have it in June itself. 23rd June. 23rd June.
23rd?
June. That's easier because May is going to be very tight.
No, this will not take more than 5 minutes, my lord. No. My lord, this is a matter where they admit that I have not been noticed, although I am the owner.
I know. But
that is the only point.
So you 10 minutes means he'll take a longer time. The shorter you take, the longer he'll take.
No, I will not take long.
No, the shorter you take, the longer he will take.
No, my lord, I am only on that. Their entire case was couched on the fact, A, this was a land acquisition proceeding initiated. If they say that it was government land, there was no question of land acquisition proceeding. They initiated land acquisition proceeding. My lord, then they filed the 30 application. They have filed the 30 application, not 5A. 5A application they filed saying that X, Y, and Z are not the owners, even though there is a settlement in their favor.
23rd June, sir. Right.
All right.
Weekly list item 14.
Let's maybe some other date minutes because due to illness of the mother of the petitioner, I could not take instruction.
What is the matter about, sir?
Matter about that minutes. In this case, I have challenged the auction sale millers conducted by the EPICL on the ground that millers really no notice has been given to the guarantor mortgagor millers who has since been expired since 2003, though they have conducted the sale in the year 2009 millers.
My lords, your lordship would recollect on the last occasion we had said that he has attended a meeting as
Yes.
per his annexure E by 1,
Right.
and thereafter your lordship had asked him to take instructions on the quantum of the loans outstanding, which is 51 crores 22 lakhs 28,363.
Correct.
Really, on the last occasion, I am drawing my lordship's kind attention to the order dated 3/8/21 minutes, wherein this on court has pleased to directed them to take instruction on the principle decided in Kharbala Industry Private Limited, Orissa versus State Financial Corporation.
It's all right, sir. Now we have asked you to do something.
Exactly. So the thing is that due to mother's illness of the petitioner,
No.
I could not,
Then we'll just.
I could not take instruction. That is the sole difficulty.
That means you're not serious, sir. Because there's enough time to take instruction.
So if
almost 1 month. 1 month is enough, sir. You have already filed a note of argument.
Yes, I have prepared. If you also will not allow, then I have to argue the matter, Millers.
Yes, you have correctly anticipated, sir. Yes.
So my sole submission before my lord that Millers.
Yes.
It is admitted fact. Both the parties that Millers have taken loan. I'm defaulter, admittedly I'm a defaulter. But Millers, due to death of the original promoter Millers, I could not run the industry Millers. And subsequently Millers, I have made representation before the EPICL authorities Millers to get its settlements. Ultimately Millers, they put the property Millers on auction Millers on 8/9/2009 Millers. You also can find that the mortgage are expired since 19/9/2003 Millers.
Right.
And they have conducted the auction 8/9/2009 Millers. And for that reason Millers, this on court Millers giving them to take instruction on the principle decided that without giving any notice, Millers, your lordship, I have also annexed that to judgment of this on court Millers, your lordship, just a glance, that Millers, even if section 29 does not say about the issuance of any notice Millers, but natural justice mandates that Millers, notice should be given to the legal, even the legal heirs of the deceased mortgagor Millers. So without giving this sum, it is null and void in law. That is my sole Millers submission before my lord Millers. I have given 2 judgments.
Yes. Yes, Ms. Pad.
Yes, my lords. That is the whole issue, my lord. In fact, he was given a chance also. He has attended the default advisory committee meeting, and there he was asked to match the amount as decided by the Khuddar Tahsildar, which he expressed his opinion that he could not. Thereafter, my lord, after the sale of property, I have said that in my counter, my lord, page 7, para 21, second para thereof, it is submitted that only after the sale of property was intimated to the petitioner submitted his offer of 2.35 lakhs, that is just 10,000 more than the offer of the highest bidder. The offer of the petitioner did not indicate the time by which the balance amount would be paid through the petitioner, though the petitioner was aware that 2.20 lakh, the sale amount was to be paid in full within 15 days time by the highest bidder.
Right.
So I believe that he was given ample opportunities
Right.
to match the
All right.
auction.
So we'll pass the detailed orders.
Okay.
Oh, dismiss that.
Weekly list item 15.
Item 15, my lord, the opposite parties filed served the copy of the counter today only. So,
all right, rejoinder be filed for the next day. Mr. 19 July.
My lord. Weekly list item 16.
This matter, Mr. Mahanti was appearing. Mr. Mahanti was appearing, but he informed me that he has already returned the brief. Because I am the retainer of this Board of Secondary Education, I called for the file and found
that it can be, it's a small matter, my lord. What has happened? The opposite party has approached the MSME council. They have directed under Annexer 1 to make some payment. But the entire problem is the payment cannot be made because there is a civil suit pending. As on the date of this, that instruction I have to take. In paragraph 10, we have mentioned that a money suit is pending against him. So
you pursue that, sir?
Well,
you pursue that money suit?
But he is liable to pay certain amounts. Before the MSME council, if any buyer is liable to pay anything, then they can direct such payment. And he has come up with an application saying that he has supplied the goods to us and we have not paid him the money. He has produced the bill. But since he has defaulted in giving the product within time, we have filed a suit against him for recovery of damages and other things. And therefore, that amount becomes a disputed amount. When that disputed amount is there, under the provisions of Section 18 of the Act, either they have to refer it to the arbitration council or they have to adjudicate the matter. Instead, they have simply directed that we should pay the money. That is why, without any reasons also, once that is disputed. So I am only to take instructions what happened to that suit. My friend, if my friend knows it, I can't say.
So far as suit, my lord, I have already stated in my counter, para 16, that suit has been already dismissed in the year 2006. Suit is not pending.
In the year 2006?
6.
Oh.
I have already stated in my counter para 16, man. The suit is not exist, man. They have not.
Right, but then you will also kindly look at the impugned order. Impugned order is Annexer 1.
Yes.
Annexer 1, you will also see, without any reasons, they have simply said that at page 10, at 11, page 11. After deliberation, the council directed the opposite parties that the President, Secretary, Board of Secondary Education, Orissa, to pay an amount of rupees 10,575 as principal, together with compound interest, with monthly rest from due date, that is at the rate of 3 times of the bank rate notified by the RBI as per the Act. The interest shall be payable with effect from so and so. This is all the entire order. You will also now kindly turn to Section 18 of the Act.
So isn't an MSME award itself challengeable?
MSME?
This order, impugned order is passed under what provision?
Under Section 18 of the MSME Development Act.
Can they not be challenged in the...
There is no other appeal provision. Because that they have to refer it to arbitration. They have to refer it to arbitration. Instead they have passed this order. Therefore, I have come.
Which provision are you saying? 18?
Yes.
18.4, my lord. The 5 persons have passed the order. They can pass the as arbitrator or conciliator under the section. 18.4. They can pass the order. They have a right to pass. That is under Annex 1. That is the impugned order.
Let me place that section. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under Section 17, make a reference to the council. On receipt of reference, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provisions of Section 65 to 81 of the Arbitration and Conciliation Act shall apply to such a dispute if the conciliation was initiated under Part 3 of the Act. where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either it shall take up the dispute for arbitration or refer it to any institution, so and so. Thereafter, the 4 comes. If those things are not, they have to be followed first. Therefore, directly they can't say that.
What do you say, sir?
Even if they are doing as arbitrator, because 18.4 said that the facilitator, the councillors are passing the order as per the exercise the power of the arbitrator. Even if, my lord, it is passing the order of the arbitrator, so no writ will apply, because if it will be taken as a order of arbitrator.
If it has to be an arbitration, sir, it will be with the participation of this person. When arbitration is there, means parties will be present, right?
Yes, both are present. All are present, they appeared and they filed the counter. Thereafter, the order has been passed on annexure 1.
When the order was passed, impugned order was passed, were they present?
Order passed. My lord, page annexure 1, page 10, my lord.
No, first of all, sir, there is no reference to this act at all. I don't think this provision was there in their minds. They probably weren't even aware of this provision. It's quite likely.
My lord, page 10, I could not follow, my lord.
I don't think this body was aware of this act.
Yes, my lord.
Were they aware, let's put it simply, were they aware of section 18 of the MSME Act?
Aware means, my lord.
Were they conscious that there is such a provision, sir? Were they conscious that there is such a provision?
Yes, my lord.
Where do they say that they are referring? Where do they say under which provision they are passing this?
Lordship, kindly see page 10, my lord.
Yes.
Impugned order.
Yes.
That is the Office of the Director of Industries, Orissa, Cuttack, order sheet, MSFEC case number, my lord. And the fortune, the OP1 is the petitioner, and the opposite party.
Sir, just understand the question first. Don't simply read the order. We have also read it, which is why we are asking you a question. Have they referred to section 18 of the MSME Act?
No, they have not referred the section 18, but they have referred the MSME Act 2006.
Sir, that much we are understanding. Sir, please don't give us some credit. We are not simply asking a question.
They have not stated the provision.
Are they aware of this provision? Therefore, they are not aware of this provision.
And when they pass the order, so that is the matter. Must have because they issue notice. The page 10 shows that, my lord. They issue notice, they appeared, and after hearing both the side, the order has been passed. So, and now the Lord is saying that they have not stated that in their petition that they have no authority to pass the order. The
amount is very small, Mr. Rao.
Small, all right, my lord. But what has happened? This Board of Secondary Education publishes books, my lord. So he was the printer. He was to supply 25,000 copies of the books. He has not supplied and raised the bill.
Can you not pay any amount? You can't pay any amount at all, is it?
No, not amount is not the question, my lord. I bow down to that. But what is the position? But if they don't supply the books, how the children will be getting the books, my lord? And in between the...
Sir, this is an 11-year-old dispute now. The 10-year-old dispute at least. When was this order passed? October 2011, more than 11 years old now.
Yes.
And you managed to get a stay. For 11 years, you've not paid 10,000 rupees.
No, 10,000 is not the question.
If it is not the question, you pay him then. No. If it is such a trivial matter for you, pay it off.
Not that way.
If it is not the question, pay it, sir.
The question is, where the acceptance is there, then it's to
What is the problem in paying 10,000 rupees?
Your lordship may kindly see section 2B.
All that is fine, but what is the problem in paying 10,000? You won't mind spending 1 lakh to pursue this matter, but you should not pay him 10,000. How is it justified?
We are governed by the rule of law.
It makes no sense, sir. After a point, all this has no meaning. You pay the principal amount, he'll agree to get the principal amount, you'll save the entire interest amount. You take the principal amount and be done with it.
उसमें direct
So principals have to take instruction because act is that is interested. The amount involved being just rupees 10,575. Concept of the petitioner states that he will seek instructions on whether the petitioner will agree to settle the case by accepting the principal amount due from the petitioner. The opposite party will take instructions on whether they can settle the entire dispute by accepting the principal amount determined to be due from the petitioner. List on.
May I please, Your Lordship?
21st June.
Weekly list item 17.
May I please, Your Lordships?
Yes.
In this case, my lord, the petitioner is a farmer. For irrigation of his land extended to 2.5 acres, he was digging a tank on his own land. And after digging about 3 meters, he came after the laterite stone, which then after coming up this laterite stone, he applied for the permission. Your Lordships kindly see rule proviso 1 of rule 3 of minor minerals rules, my lords. Minor minerals rules, Your Lordship got it, my lords. Lordship proviso says, that extraction, collection, and for removal of minor minerals by a person from his own land for normal agricultural operation or other bona fide domestic consumption shall not be construed as qualifying operation, as quarrying operation, my lords. So, my lords, it is not a quarrying operation, but irrespective of the facts, since he is a farmer and ignorant about the facts, he applied for the permission that is at page 19, my lords. And basing upon that permission, my lords, he was given permission that is at page 22, 23. Your Lordships kindly see that last portion of the page 23, my lords. This is rule Sudhir Kumar Sendha under Rule 73 1B of OMMC Rules 204. This is valid for period of 90 days, my lords. So he was given permission to extract laterite stone for a period of 90 within a period of 90 days, my lords, subject to payment of the revenues, that is 79,000 and all. My lords, comes to the next page, that is page 24, my lords. Page 24, that is the order passed on 23/6/2012, my lords. On 23/6/2012, the order was passed that since he has not deposited the revenue amount, so his permission to extract is cancelled, my lords. Permission was, my lord, 90 days, but after 37 days, the permission was cancelled because on the ground that he has not deposited the amount, my lords. But irrespective of the fact, my lords, the petitioner was not informed about the order for payment of the revenue amount, my lord. This is, my lord, first occasion, my lords. Then, my lords, since he applies the matter to the Tahsildar, again the Tahsildar asked him to file a second application, and on the second application, my lords, the order was the permission. He was said that since it is not within Monrega scheme, so his application was there. Monrega scheme is, my lord, no way concerned with the extraction of the minerals for the purpose of irrigation of agricultural land, my lords. Next, again, when he raised objection, my lords, then he was granted permission. That is at, my lords, page 41, my lords. At page 41, he was given permission originally for 90 days, but that was again manipulated to 30 days so that he cannot get the time to deposit the amount, my lords. Here, my lords, petitioner is a farmer. He doesn't require the extraction of quarry is minerals doesn't amount a quarry. Only thing he requires, that is under subsection 2 of section 3, that is transportation for his own use. So unless he is given permit for transportation of the minerals for his own use, he cannot transport the minerals, my lords. If he extract the minerals and stack it on his agricultural land, so it will be, instead of agricultural land, it will become a stony land. So, my lords, subsequently he brought it to the notice of the sub-collector. sub-collector says that as per amended rules of 2019, that no private persons shall be given for extraction. It is not minors for the private persons. This proviso 2 subsection 3 has not been deleted, and that is relating for the commercial purpose. I read my lords the paragraph 9. Your lordships, first of all, I lordship bring it to notice the page 54. That is the order of the sub-collector. On perusal of the prior petition, the undersigned has been pleased not to give further opportunity as applied for, as per paragraph 9 of OMMC Amended Rules 2014, provided that no quarry permit shall be granted to anybody other than the state agency, subject to the proponent for the public purpose. My lords, paragraph 19 of the Amended Rules says that provided that no quarry permit shall be granted to anybody other than the state agency or project for public purpose. My lord, again, I take your lordships to the provision of subsection, proviso to subsection 3, first proviso, that this taking extraction of quarry minerals by a farmer from his own land for agricultural purpose doesn't amount to a quarrying operation, my lords. As a result of this, my lords, this petitioner, who is a farmer, unable to dig a tank and irrigate his land, and thereby deprived of his livelihood from the agriculture purpose, agriculture scheme, my lords. This is my lord's grievance before your lordships, my lords.
Aravi's comment has come, my lord. But should I grant me a short adjournment? I'll file a reply, my lord. Because here what has happened, my lord, he has, due to non-deposit of the royalty and other dues, my lord, his permit has been cancelled.
Party seeks and is granted 1 week's time to file. Yes, 1 week is enough?
Well, 10 days time.
Or 2 weeks time to file the reply, rejoined for the next. Let's on 14th July.
Weekly list item number 18.
None of these. Not possible.
But 18 would have become influx. So I am for the opposite party OPSC, my lord.
All right. It's okay. We're dismissing not possible.
Yes. Weekly list item 19.
Lord, the last occasion, my last order, your lordship directed file an affidavit, my lord, to the opposite party. They have filed an affidavit.
Mr. Mudili, my lord, is supposed to handle this case, my lord. He is held up in another court, my lord. But with pursuant to lordship's direction, my lord, we have filed an affidavit. I've also served copies.
Yes, ma'am.
Let my lord go through that affidavit.
Case is, my lord. Petitioner was a grade 1 bench clerk, my lord. The Joseph of Khurda, my lord. In the year 2016, there was a DPC for consideration of promotion to the Sirastadar, the district court, my lord. And he is the second senior most person in the gradation list. And the number one is KC Guru, my lord. And the DPC, as from the affidavit, my lord, the DPC was sat on 29/7/2016. And in that DPC, number 1 KC Guru was selected and got promotion. And just after a month, he got promotion 1/8/2016 and retired on 31st August 2016. My lord. And the petitioner is the second person, my lord. Knowing the fact that he has also 5 months left for superannuation, he was not promoted. And just after his retirement, my lord, they convened another DPC and promoted the another persons. And he was deprived of getting promotion during the last period, my lord, 5 months of service. And your lordship in last occasion directed to obtain instruction, my lord. Your lordship order dated 16/3/2022.
Whether there are vacancies.
Yes, pursuant to that, we have filed the affidavit.
And they stated that, my lord, the DPC was sat on 29/7/2016. Promotion order was issued on 31st July 2016. And he joined on 1/8/2016, retired in 31st.
So what have you said in your counter?
My lord, our counter, my lord, lordship, kindly see page 2, my lord. We are saying that the DPC has to be formed, my lord. A proper procedure has to be followed. The present petitioner, the other person who has been appointed in place of the present petitioner, my lord, that we have, that with regard to his role, my lord, we have mentioned in the additional affidavit which were filed on.
No, the same DPC had already considered him. It's like arranging 1 and 2 and 3.
Because he had gone through that process of DPC, my lord.
Correct. And he
has-
was next in line, sir,
Yes.
after this KC Guru.
May I just place that part? It is humbly submitted a committee of consisting of 3 members, including district judge, to take up the matter regarding promotion to district court Sirisadar was constituted on 21/6/2016. The meeting of the DPC was held on 29/7/2016. The up-to-date CCR and performance report of grade 1 bench clerk have been verified by the DPC in that meeting. The CCR as well as performance report of the petitioner who was holding the post of grade 1 bench clerk at the relevant time was also called for the said purpose. On verification of the gradation list and finding no adverse remark in the CCR of Sri Krishna Chandra Guru was found, and he was found suitable by the DPC for promotion to the post of Sirisadar. After promotion of Sri KC Guru to the post of Sirisadar, the petitioner is not entitled in any manner to have been given promotion on the basis of resolution passed by the same DPC. Rather, the claim of the petitioner for promotion to the post of Sirisadar on the retirement of KC Guru required fresh consideration by the DPC among other eligible bench clerk grade 1 as per rule, my lord, of the Orissa District Subordinate Courts rules, my lord. No select list is prepared for promotion to the post of Sirisadar. Promotion is based upon merit cum suitability with
All
due
that is
regard
fine,
to-
sir. So
My lord.
he's next in the merit.
My lord, he has retired on 31/2017.
Correct.
The DPC was held on, my lord, 29/7/2016.
Yes.
My learned senior would
Yes.
In fact, in the DPC held, the other person was selected as the Siristadar.
Correct.
There was no select list was prepared, like serial 1, 2, and 3.
Does it have to be? He's next in the line. Is it your case that somebody else was also there?
No. Our case is that he has to be adjudged by the Department of Promotion Committee.
He was, sir. His case was put up. KC Guru was found most suitable. KC
Yes.
Guru was promoted.
Yes.
You naturally know who are the others in the fray, right?
In the counter, my lord, they have admitted I am the second person. After KC Guru retirement, I am the senior most grade 1 BC.
But the criteria is otherwise. Criteria is, well, that's why we have stated in the additional, that's compliance affidavit, that though his case was under consideration, but he was not given the promotion to the post of Siristadar. Rather, Mr. KC Guru was given promotion.
KC Guru retired, sir.
Yes, after retirement, we have stated that there was no select list, so that
No,
one
is it
vote-
his problem? The problem is you not held a DPC. It's
Yes.
not his problem.
DPC was not held till his
So why
retirement.
should he suffer because it was not held is the question, sir. When a person retires, you anyway have to promote somebody else. So you either do it immediately after the man retires or anticipating his retirement, you hold a DPC.
Your Lordship, may direct that DPC will be constituted and his case will be considered for promotion. If he will be found suitable, then he will be given notional promotion.
All right, an extraordinary DPC be convened. You say the counter affidavit filed by the opposite party. The additional affidavit, is it? Or
Yes, compliance affidavit.
Compliance affidavit of the opposite parties has been produced. Is directed that what do you call it? Extraordinary DPC? No. A DPC be convened to consider the case of the petitioner for promotion as Siristadar.
Along with others.
At the relevant time, along with others who were eligible to be so considered at the relevant point in time, that is on the retirement of KC Guru on 31st August 2016. Full stop. Since the petitioner is superannuated in the meanwhile, you have superannuated. If he is found suitable for such promotion, it shall be notionally given to him from the earlier date with the pension being reworked, but there will be no arrears of pay.
Yes, ma'am.
The entire exercise will be completed within a period of 8 weeks. And the decision communicated to the petitioner not later than 4th July 2022.
All right. So, dispose of the writ petition.
Yeah, it's disposed of.
Appeal list item 21.
21 years, I am appearing
in person, I am challenging the notification of the central government by which the advocates have been removed from the list of eligibility criteria for appointment in the post of a presiding officer of the DRTs. And you will also kindly go to the impugned annexure.
Presiding officer
at 128. At 128. First para. A person shall not be qualified.
Yes. No reply has been filed, sir, still.
No reply has been filed.
Mr. Pari?
Several adjournments have been taken by them.
Yes, my lord.
What happened?
My
No
lord,
reply, sir.
My lord, I'm sorry, Mr. Bhukta might be put. I have allotted to him. Anyhow, my lord, this time that restriction has been lifted. What I heard that this after this judgment of the Honorable Supreme Court, Mr. Nageshwar Rao has passed and Justice Nageshwar Rao has passed in judgment. Thereafter, the government of India has lifted the same, and the lawyers have been given the scope to submit their applications.
No. After
So you just file an affidavit, sir.
Yes, my lord, give me some another.
Mr. Pari states that he will file an affidavit positively.
No, they will not file the affidavit, I know, because the Secretary Law and Justice is his appointing authority. He is not there, doesn't dare to get his counter affidavit.
What is this submission, sir?
Now see what is his submission. The judgment was passed in November 20, November 20 by the full bench, and in 12th July 21.
Mr. Pari says that he will file his affidavit not later than 20th June 2022. Rejoinder that to Feni be filed before the next date. List on 5th July, sir.
Kindly call for the record along with the affidavit also.
Sorry?
We don't kindly call for the records from them. What happened to this?
What is record? No, not necessary for this, sir. Once they make a statement that you're eligible to apply, you become eligible. That's it. Yes.
Weekly list item 22.
Eligible.
Getting that disposal of drugs matter. It is regarding implementation.
So we'll pass a set of instructions, further instructions today. There's some progress made.
In 3 cases, plus certification process is complete.
Sir, we are constantly getting this response from our judges that there are not enough applications filed. The prosecuting agency is not filing applications.
For applications are pending. Which applications are pending? That is under Annexure 1 to the writ petition.
I know those applications are in other districts.
Other districts. Yes. I'll take instruction.
So you see, further directions. The following directions are further issued in continuation of the earlier directions issued, and then you leave that list on 18 July, sir. 18 July. We hope that substantial progress will be made by that.
Weekly list item 23.
Item 23, my lord, last chance. As a last chance, lots of grant me 1 more time more to file count.
All right. Final opportunity to file counter affidavit within 2 weeks. Rejoined up to the next week. 19 July.
Weekly list item 24.
Taking up 24.
Item number 24.
24 pursuant to lots of direction, my lord. The villagers of petitioners have prayed that their PHC, primary health center, should have been there in their villages, and you also directed the CDMO to make a spot visit and file a report.
Correct.
So meanwhile, the CDMO was in fact inspected the entire village area and presented a report to the additional chief secretary health, and the report is under examination by the.
Okay, it is stated that pursuant to the order passed by this court, the CDMO.
Yes, CDMO
Khorda visited the villages in question and has submitted a report to
the additional chief secretary health and family welfare.
Additional chief secretary health and family welfare, who is to take a decision, is it?
Yes.
On opening the PHCs.
Yes, ma'am. In fact, I was inquiring the procedure regarding the opening of. They are saying that there is a subcommittee. There are 3 committees constituted, but the additional chief secretary will coordinate with all those departments.
Correct. So the PHCs now be opened at the earliest in the villages where they are required to be immediately opened. The compliance affidavit be filed by the next date.
Your lordship saying PHC to be opened earlier
wherever it is required.
Because the feasibility report somehow, my lord, the CDMO had said that if the population of that particular locality will be taken into consideration, that doesn't come into, my lord. It is, since it is not a hilly area, and the population is 19,000 odd. So unless it is more than 30,000, a PHC cannot be constituted in that particular zip.
I'm appearing for the.
How is that a relevant criteria, sir?
My lord, they will examine. So there is a committee which will examine the report submitted by the CDMO. So at least 2 months time be given to us to examine.
Not 2 months, sir. Anyway, it will go beyond vacation. It's all right. The compliance affidavit be filed by the next date. List on 6 July.
Obliged.